Committee will come to order without objection. The chair is authorized to declare a recess at any time pursuant to Committee Rule 2 and House Rule 11, Clause 2. The chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, to lead us in the Pledge of Allegiance. Pursuant to notice, I call up the report recommending the House of Representatives cite United States Attorney General Merrick B. Garland for contempt of Congress and move that the committee report it to the House. The clerk will report the report.
Resolution recommending that the House of Representatives.
Without objection, the report will be considered as read and open for amendment at any point. The chair now recognizes himself for an opening statement. Special Counsel Robert Hur stated on page 1 of his report, quote, "Our investigation uncovered evidence that President Biden willfully retained and disclosed classified materials after his vice presidency when he was a private citizen. Joe Biden not only kept information he wasn't allowed to keep, he shared it with people who weren't allowed to see it. He shared that information with his ghostwriter. Special Counsel Hur said that President Biden had strong motivations to do so and to ignore the rules of properly handling the classified information in his notebooks. In fact, he had 8 million reasons to ignore the rules. Joe Biden shared some of the classified materials he kept with his ghostwriter, who was writing a book for which Joe Biden received an $8 million advance. So we have motive, $8 million motive, and we have the elements of the crime, knowingly keeping, knowingly disclosing classified information. But all this, and Special Counsel Hur declines to prosecute Joe Biden because he is, quote, a sympathetic, well-meaning, elderly man with a poor memory. And that brings us to today. Following the release of Special Counsel Hur's report, we subpoenaed the transcript and audio recordings of Special Counsel Hur's interviews with President Biden and his ghostwriter, Mark Zwanitzer. To date, Attorney General Garland has failed to produce the audio tapes. To determine whether Special Counsel Hur appropriately carried out justice by not prosecuting, not recommending for prosecution the president, the recordings are necessary. The transcripts alone are not sufficient evidence of the state of the president's memory, frankly, because the White House has a track record of altering the transcripts. Just weeks ago, during a public speech, President Biden read a teleprompter instruction to pause. He stated, "Imagine what we could do next, 4 more years, pause." But when the White House put out the transcript, it didn't include the word pause. In that case, and in this case as well, the video and the audio recording is the best evidence of the words that President Biden actually spoke. The department's refusal to produce the audio recordings of Special Counsel Hur's interviews with President Biden amounts to a demand that the committee trust that the department created and produced interview transcripts are actually accurate and complete. Transcripts that the White House and President Biden's personal counsel likely had access to before they were finalized. The department has a legal obligation to turn over the requested materials pursuant to the subpoena. Attorney General Garland's willful refusal to comply with our subpoena constitutes contempt of Congress. Now today, this morning, we get an 11th hour invocation of executive privilege. President Biden is asserting executive privilege for the same reason we need the audio recordings. They offer a unique perspective. This last-minute invocation does not change the fact that the Attorney General has not complied with our subpoena. With that, I would recognize the ranking member for an opening statement.
Thank you, Mr. Chairman. 20 million taxpayer dollars. Chairman Jordan, who consistently opposes government spending on everything from feeding children to education and health care, has spent 20 million taxpayer dollars of this Congress to investigate his various conspiracy theories. And what exactly has he delivered to the American people on their $20 million investment? Exactly nothing. No evidence that the conspiracies are true, no indictments, no impeachment, no wins of any significance. If the chairman of a board of directors took $20 million from the shareholders of a company and delivered nothing, he'd be fired at the next board meeting. And the chairman knows that if he doesn't come up with something to show for the $20 million he spent, the MAGA political base may stay home next November. So he and Chairman Comer are scrambling in a desperate attempt to look like they have accomplished something. The chairman wants to make it seem like he uncovered some wrongdoing by the Attorney General. In reality, the Attorney General and DOJ have been fully responsive to this committee in every way that might be material to their long-dead impeachment inquiry. Sometimes they've been too responsive, in my opinion, given the obvious bad faith of the MAGA majority. The chairman was desperately hoping that Special Counsel Hur would indict President Biden for mishandling classified documents, so that the chairman could attack President Biden and misdirect the American people away from Trump's treacherous handling of classified information. In reality, the special counsel cleared Mr. Biden of wrongdoing. The chairman hoped he could intimidate prosecutors out of indicting Donald Trump for his crimes, but Donald Trump has been charged with 88 felonies. The list goes on and on. The chairman digs and searches and intimidates, but there's just no there there. So what do our Republican friends do when an investigation turns up short? Simply put, they engage in fantasy. That's what they are doing here today. They accuse the Attorney General of withholding key evidence, but the Attorney General has substantially complied with their every request. DOJ has produced 92,000 pages of documents this Congress alone and made dozens of witnesses available for interviews, hearings, and briefings before the committee. That's more pages of documents and more witnesses than the Trump Justice Department produced to this committee in 4 years. With respect to the February 27th, 2024 subpoena, the department turned over all the information Republicans asked for. There's been no obstruction, only cooperation. This morning, the President exerted executive privilege over the audio files at issue. In the letter informing the committee of this assertion, the Department of Justice noted that producing the audio recordings would, quote, raise an unacceptable risk of undermining the department's ability to conduct high-profile criminal investigations. In particular, investigations with the voluntary cooperation of the White House officials is exceedingly important, close quote. Chairman Jordan claims that he needs this records to understand the pauses, pace, and tone of the conversation. This is absurd and clearly pretextual, and in any event does not outweigh the substantial concerns expressed by the President and the Department. Moreover, with respect to the recording at issue in this report, a complete transcript has already been provided to the committee. The only thing that has not been produced is the recording itself, which can be easily manipulated. This is not an idle concern. Last year, a witness testifying in a closed-door deposition told us that she was the victim of a manipulated video amplified by Republicans on this committee and that it contributed to a flood of death threats against her. This isn't really about a policy disagreement with the DOJ. This is about feeding the MAGA base and getting Donald Trump reelected. But don't take my word for it. Take it from the chairman's mouth. Quote, I'm busting my tail to get Donald Trump reelected. Quote, we need to make sure Donald Trump wins. Quote, it's so important that we stay engaged and help Donald Trump get back in the White House. Close quote. And clearly, Donald Trump needs the chairman's help to win the White House. Because Trump has been indicted 4 times. Right at this very moment, he faces 34 charges in a New York State court for falsifying business records and making hush money payments to catch and kill information that could be harmful to Trump's reelection campaign. He faces 40 charges in a federal court in Florida for his mishandling and withholding of classified documents that put national security at severe risk. 4 charges in a federal court in Washington, D.C. for his attempts to overturn the 2020 election results and fueling the insurrection on January 6, 2021 at the United States Capitol. 10 charges in Georgia State Court for attempts to intimidate and force officials to overturn the lawful election results in the 2020 presidential election. And that's not all. You're going to hear a lot about President Biden's memory today. Republicans won't mention that Biden has been ranked as one of the most successful presidents of our time. They won't mention the once-in-a-generation transformative legislation he has ushered into law. They won't mention Special Counsel Hur's comments to President Biden about his, quote, photographic, unquote, memory. They'll just go on and on about a couple of gratuitous, widely contradicted comments in the Hur report that suggest the president has a poor memory. What Republicans won't show you is the mounting evidence that Trump is mentally incompetent to hold the office of the president. The late, great Hannibal Lector. I can't even begin to understand how Republicans have chosen this man as their champion, but they have. And now House Republicans are paying for it by flocking to the sidelines of his criminal trial, sacrificing their integrity to defend him against, frankly, indefensible acts. Almost everybody who worked for the former president seems to know that Trump is unfit for office and that these acts of public humiliation on his behalf are wrong. What more evidence do my colleagues need? Trump once said that he could shoot someone standing on Fifth Avenue and would still keep his supporters. Well, at least in this chamber, that's obviously true, and it truly saddens me. I've been in this body for many years, and although we've always had our disagreements, I've never seen members of Congress so readily turn on democracy itself in service to one man. I never in my life thought I'd see members of Congress readily attack law enforcement officers to protect a criminal. I never thought I'd see members of Congress defend and minimize a coup attempt, as if the rioters who stormed this building and the Trump associates who led them here were somehow patriots. But here we are. I think Chairman Jordan knows that this markup will amount to nothing. Like most of the bill's House Republicans have pushed on purely partisan lines, this contempt resolution will do very little, other than smear the reputation of Merrick Garland, who will remain a good and decent public servant no matter what they say about him today. This markup may give Donald Trump something to watch on Fox when he gets home from his criminal trial tonight, but it will almost certainly not convince the Department of Justice to produce the one remaining file in question. Like the broader impeachment effort before it, this contempt resolution will have been a partisan stunt destined to fail from the very start. It is a total waste of time. The American people actually need us to do important work, to fund the government, to secure affordable health care, to reduce inflation and housing costs, to help them take care of their children and families, and to keep our nation safe. I'm tired of these games, and so are the American people. I urge my colleagues to oppose this measure, and I yield back.
Gentleman yields back. Chair to recognize himself for the purpose of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to the committee report.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes himself to explain the amendment. This amendment makes a small grammatical change on page 10 of the report. It does not affect the substance of the report. I yield back. Who seeks recognition? Question? Gentleman from North Carolina is recognized.
Thank you, Mr. Chairman. This is a very simple matter. There is no ground whatsoever to withhold the audio tape. That tape must be quite something. If the administration, if the president has decided to assert executive privilege to keep it from the committee in the course of an impeachment inquiry, think about it. The basis for withholding the audio recording when the transcript has been furnished must rest on something about the recording that is distinct from the information contained in the transcript. For example, what if the committee had made a request for just a different copy of the transcript? Now, that's unlikely to happen, but no reasonable person would ask for it either. The president and the White House have contested what was said in the interview. The special counsel, in his report, predicated his decision not to prosecute an obvious violation of statute in the president's reading from classified information to his ghostwriter to satisfy the terms of his $8 million book retainer, on his finding that the president was elderly and forgetful. In other words, he placed tremendous reliance on what is called demeanor evidence. The president and the White House have viciously attacked the special counsel's characterization of the demeanor evidence. That is, whether and to what extent the president appeared to have limited capacity as a witness to testify from memory. Now, the transcripts do not capture demeanor evidence. Transcripts are often imperfect, especially to convey the timing of question and answer and disfluencies of a witness or hesitations, among other things. All of that is demeanor evidence. That's the reason, among other things, that it is absolutely standard practice in litigation in American courts for parties to be entitled to record testimony by more than one means, through a transcript, and then if they choose, through another method, an audio or video recording. Here's a reading from Rule 30b-3b of the Federal Rules of Civil Procedure. Any party may designate another method for recording the testimony in addition to that specified in the original notice. It's pretty straightforward. Given that the evidence is contradicted by the special counsel and by the president as to the reason the president has escaped criminal prosecution for an obvious violation of statute, and because this committee sits by vote of the House of Representatives to conduct an inquiry about the potential impeachment of the president, this committee needs the demeanor evidence the same way any party would in any such matter being litigated. And the notion that there is a basis for a claim of executive privilege here, and what has been articulated by the Justice Department, by the Attorney General, is that it would deter future occupants of the White House from cooperating with criminal inquiries because the interview would be made available and therefore it was going to be exposed, but the transcript's already been provided. What possible basis could there be that would impair future White House cooperation with criminal investigations if what the department is contending is just the same information in an audio recording form is also furnished? That is an incomprehensibly absurd position. And so there's nothing to it whatsoever. This committee cannot be deterred in proceeding with the contempt resolution, in my view. And one can question motives or attack motives or whatever, but it's just as straightforward as it can be. It's a simple presentation of demeanor evidence that is important to this committee's investigation, inquiry into the potential impeachment of the president, and it should be accomplished and done forthwith. I'm for it. Let's go. Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from
Chairman.
the ranking member is recognized.
What? Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find Merrick.
Point of order reserved by the gentleman from California. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, this amendment adds language from the most recent correspondence with the executive branch to the report. Today, the Justice Department and the White House wrote to the committees to inform us that the president was exerting executive privilege over the audio recordings. This assertion of privilege is used to protect important law enforcement interests. As the Attorney General wrote, the Justice Department has a vested interest in protecting, quote, materials related to a closed criminal investigation where disclosure is likely to damage future law enforcement efforts, close quote, which is the case here. The Attorney General further explains that producing the audio recordings to the committees would raise an unacceptable risk of undermining the department's ability to conduct similar high-profile criminal investigations, in particular investigations where the voluntary cooperation of White House officials is exceedingly important. The White House also wrote to the committees to explain that the President's exertion of executive privileges is based on his, quote, long-standing commitment to protecting the integrity, effectiveness, and independence of the Department of Justice and its law enforcement investigations. Chairman Jordan claims he needs these recordings to understand things like tone or pauses. This is absurd, and the chairman has made no attempt to explain his reasoning. His claim in no way overcomes the executive branch's substantial interest in protecting sensitive law enforcement investigations. What high-profile witness would ever voluntarily cooperate with a law enforcement investigation if they knew that audio files of their conversations would be released to committees who are seeking those files for purely political purposes? This amendment simply ensures the report is complete and up to date. I urge my colleagues to support the amendment, and I yield back.
Gentleman yields back. The gentleman from California withdraws his point of order. The gentleman from North Dakota is recognized.
Thank you, Mr. Chairman. I move to speak in opposition to the amendment. They don't get to choose. They don't get to choose. We spend a lot of time in this hearing, in this room, talking about, I've been an advocate for recording interviews, recording arrests, doing all of this. There's a pretty known legal precedent and legal rule of the best evidence rule, and it exists everywhere. The person providing the evidence doesn't get to choose the manner and form in which the evidence is provided. And this also happens to be a pattern. 5 minutes before the Her hearing, we got the transcript. 5 minutes before this hearing, we get the invocation of executive privilege. There's a difference between a transcript and a video and audio. And I don't possibly understand the argument of, we'll release the transcript, but we won't release the tapes, and that's going to determine whether or not somebody participates in an investigation, which, by the way, that can be compelled to be done as well. The argument that this is somehow anything other than the DOJ trying to pick and choose which pieces of evidence or which parts of evidence are what they determine is the best evidence to our committee is just, quite frankly, not based in any precedent under law. I spent 10 years doing this. I spent 10 years doing discovery requests. I never asked for permission. I'm entitled to what it is. They don't get to determine what we get. That is not how the system works. And it can't be how the system works. Because otherwise, the people who you are trying to conduct oversight on determine what information you get to conduct that oversight. That is just simply not how the separation of powers is set up. It's not set up in how any legal investigation in any jurisdiction in any form exists anywhere in the country. The audio tape exists. That is the best evidence in which to conduct oversight, and this committee is entitled to it. And with that, I yield back.
Gentleman yields back. Who seeks recognition? The gentleman from California.
Thank you, Mr. Chairman. I speak in support of the amendment. But first I want to talk about both what this committee and what this Congress is doing to the rule of law. Earlier this week, we witnessed the spectacle of the highest-ranking Republican in the country, the Speaker of the House, someone in line for the presidency, standing outside a Manhattan courthouse in a hush-money payment to a porn star trial, vouching for the good moral character of the defendant. Now, I would imagine if you asked a younger Mike Johnson some 10 or 15 years ago, could you ever imagine you would stand outside of a courthouse in a hush-money payment to a porn star trial and vouch for the moral character of the defendant? He would never imagine that possible. But like the proverbial frog in the boiling pot, what we have seen, not just with the Speaker, but with so many of the Republican leadership over the last several years, is one surrender of moral authority after another surrender, one betrayal of what one once stood for, followed by another betrayal, followed by another, until you find yourself standing outside of a Manhattan courthouse, vouching for the moral authority and character of someone who possesses none. And not just losing yourself and losing any sense of right and wrong in the process, but here denigrating the very institution of justice, making the false claims, the patently false claims that this trial in Manhattan was somehow about keeping Donald Trump off the campaign trail, something the Speaker knows is patently false, but willing to repeat.
And this is where we are, where our highest ranking official, Republican official, is essentially telling the American people, don't trust our system of justice. Don't trust the rule of law. And here in this committee, we see something very similar. We see a Republican U.S. attorney brought on to investigate the president. We see him make a report to this Congress that there is nothing prosecutable in what he was able to find. We see him at the same time failing to make a prosecutable case, deciding the next best thing he can do is lob a political grenade in his report and politically belittle the president. And we see this committee unable, after months and months and millions of dollars to make any kind of an impeachable case, decide to follow Mr. Hur's tainted example. We can't make a case for any impeachment. There is no high crime. There is no misdemeanor even. And so we will do the next best thing, and we will use this to political advantage by subpoenaing tapes of an interview we already have the transcript for. And why? Because the Republicans in this committee have moved from being the criminal defense firm for the president to being essentially an adjunct of the president's media advertising firm. They want the video for Donald Trump's campaign commercials. That's where this committee has become, the committee on the judiciary, the committee that is centered or supposed to be centered on the rule of law and on justice. And what are we doing? We're holding the Attorney General of the United States in contempt. And for what? Because he won't give video material for a campaign commercial to this committee. On behalf of a president who is a criminal defendant in a hush money payment to a porn star case in New York, the first of many criminal trials that he will face. This is where we are. This is where we are. I first joined this committee, now it's been over 20 years ago. And I suppose like a young Mike Johnson, I could have never imagined this committee would engage in such a thing. It's not as if 20 years ago this committee was some bastion of bipartisan comity. It wasn't. We might and did disagree on abortion and on guns and on the whole host of other policy issues. But I don't think any Democrat or Republican on this committee would have ever imagined it would be brought so low as to hold an attorney general in contempt because it can't get a video for a campaign commercial when it was already given the transcript. But this is where we are. And I think just day after day, moment after moment, year after year, we lose sight of how far we have fallen and any sense of what we are supposed to be about in this committee. And I don't imagine anything I have to say is going to change that, but I do think every now and then the country needs to be reminded that there is nothing okay about this. There's nothing right about this. There's nothing normal about this. We need to get back to demonstrating some devotion to our constituents and the rule of law. And with that, I yield back.
Gentleman yields back. The gentleman from New Jersey is recognized. Will the gentleman yield for a second?
I will yield.
Yeah, I just want to point out, we're not seeking a videotape. We're seeking the audio tapes to correct the statement from the gentleman from California. And the Democrats, I believe, held the Attorney General of the United States in contempt a couple Congresses ago when they held Bill Barr in contempt. I yield back to the gentleman from New Jersey.
Thank you, Mr. Chairman. Look, we got to get focused here. The gentleman from California, he's kind of, again, trying to take our eye off the ball. This has nothing to do, this particular issue right here, what we're doing with the courthouse in New York City, this doesn't have anything directly to do with what is going on with President Trump there. And I would be glad to engage in a colloquy or a debate or discussion about how awful what's happening to President Trump is, but that's not the issue here right now. This has nothing to do with the campaign. It has nothing to do with the fact that the speaker did go, as he should have, to support President Trump. But this isn't the issue. It has to do with Special Counsel Hur, and it has to do with what he said. And by the way, he never said it wasn't prosecutable. He decided not to pursue the charges due to the assessment that a jury would find President Biden's age and poor memory as an excuse for mishandling those documents. I didn't say that. Our chairman didn't say that. The special counsel from the Department of Justice said that. The subpoena of the Attorney General is necessary because the Department of Justice has refused to provide the audio recordings of interviews that are crucial for determining the special counsel's assessment of our current president. It's essential for this Congress and the American people to determine whether special counsel Hur's assessment is accurate or not. And I'm going to tell you why. And the folks on the other side and the left here are in a bind. Because if our commander-in-chief is so incompetent that he cannot stand trial, he's not fit to stand trial, then he's too incompetent, for God's sake, to be the leader of the most powerful nation on the face of the earth. If President Biden is competent and special counsel Hur's assessment was incorrect, then President Biden should face a jury for his crimes of mishandling classified materials. You know, President Trump's facing the full weight of the Department of Justice in his own case on this issue, even though he had the authority to declassify documents because he was the President of the United States when he did it. President Biden, on the other hand, mishandled classified documents, both as a vice president and then as a senator. Guess what? Members of Congress, vice presidents, U.S. senators don't get to take classified documents and remove them from the SCIF. They just don't get to do that. They don't get to declassify documents. He didn't have the authority to declassify. So the audio recordings, why do we want them? Because they're going to reveal whether special counsel Hur's assessment was correct and our president mishandled classified documents, or it will reveal he's incompetent and he's not competent enough to even stand trial and therefore not competent enough to be the president of the United States. That's the choices we have. We've got two choices here. He was competent and he broke the law, or he's incompetent and he's so incompetent, he's such a bumbling old man that he can't even stand trial because they wouldn't really be able to do much with him. That's what we want to find out. That's what we need to know. Either way, it'll be clear our president is unfit to lead, in my opinion, and likely why the DOJ is so damn hesitant to share it. I'll tell you what, anybody else, probably anybody on this committee, if you ask them to share the audio of something we said, believe me, anything I'm saying now you can share anywhere. And you can share anything the chairman says or any of our esteemed members say here on either side. So why don't they want it? They've got a reason, because they're in a bind. And am I willing to set the precedent that subpoenas from Congress and this committee can be ignored? Are you willing to do that? I don't think so. I don't think that we want that to happen. Are we willing to perpetuate, if the president is competent, a two-tier justice system? Again, we see it again, being wielded against one person but not another? The answer to the question should be no. The information requested in this subpoena is crucial. We need the information, not just for uncovering whether our president has acted in a manner deserving of impeachment, but also because the American people deserve to know the answers. We shouldn't be hiding the answers and the truth from the American people. For those reasons, I don't support this amendment, and I do strongly support holding the Attorney General in contempt of Congress. Let it loose. Give us the information. If there's nothing there to worry about, you should have no problem letting us know and letting us see. Let the light in. Let the sunshine in. I yield back.
Gentleman yields back. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I want to address a couple of things quickly before I get to the amendment. But one of the arguments I'm hearing from the Republican side over and over again is essentially questioning Mr. Hur's conclusion not to move forward with a prosecution. But I did want to remind my colleagues that under, Mr. Barr, the Department of Justice has taken the position that the committee, referencing this committee, the House Judiciary Committee, has no legitimate role in demanding law enforcement materials with the aim of simply duplicating a criminal inquiry, which is, of course, a function that the Constitution entrusts exclusively to the executive branch. So to the extent you're arguing that you don't agree with his findings and you want to sort of replicate them or go through them again, Mr. Barr argued against that 5 years ago. With respect to the underlying amendment, or the amendment to the ANS, there's a major problem here with moving forward with the language in the amendment, because it's based on the predicate that, and I'll read it, to the date the department has refused to produce the audio recordings despite not having invoked any privilege to justify its failure to comply with the subpoena. And one of the conclusions that it reaches at the end, as a justification for moving forward with contempt, the Attorney General has further invoked no constitutional or legal privilege relieving his obligation to fully respond to the committee's subpoenas.
Gentleman yield?
Sure.
Yeah, we're drafting an amendment. We understand that has to be dealt with in light of the last-minute executive privilege assertion coming from the White House. So we are drafting that amendment, but we are running it past House Counsel. So the majority intends to offer an amendment for the specific language that the gentleman cited.
Will the committee then adopt the ranking member's amendment?
No, we have our own.
Well, I guess we'll have to take a look at it when it gets here. But, you know, moving forward on this basis, even if you amend the language and add that, I want to remind the committee that where there's an assertion of executive privilege, according to Nixon, which is the case that you all have cited, I don't know if you're going to strike that too, but upon receiving a claim of privilege from the chief executive, it became further the duty of the district court to treat the subpoenaed material as presumptively privileged and required the special prosecutor to demonstrate that the presidential material was essential to the justice of the case. And that's because it was a pending criminal case, so moving forward at that point, so there's an expedited process. We obviously don't have an expedited process here, but just to point out and be clear about this, the court said this is presumptively privileged. And so moving forward as if that's not the case, I think is deeply problematic. One of my colleagues over there a minute ago said something about you don't get to choose, but that's exactly what happens when you assert a privilege, especially executive privilege. And the references from the other side with respect to regular civil litigation, which is fine, I engage in regular civil litigation too, but this is litigation between the Article I and Article II branches of the United States. This is constitutional magnitude. So rushing through this quickly, I think, is misguided, and I think it'll lead to, hopefully, a court telling the committee that we're going down the wrong track, we're abusing our power for oversight, especially in the instance where we've got a special counsel that's already been appointed, has reviewed the issues, has come back and stated clearly that there's insufficient evidence in his view to move forward with the prosecution. And I think it's especially problematic too if we have to take it to a court again, that there's no evidence here of a refusal to cooperate. In fact, you've got the exact opposite. The above and beyond language in the Barr language, in the Barr letter, is clearly met here too. We've got Mr. Garland. He wasn't legally required to release the report, but he did. He wasn't required to release the transcript, but he did. And as was pointed out a minute ago by the ranking member, the department's produced 92,000 pages of documents. We've had, I don't know, 40 or 50, lawyers from the Department of Justice come and testify, a couple of them in the middle of a criminal prosecution, which is totally unprecedented. So for these reasons and more, I'm urging my colleagues to rethink this approach, because I think ultimately it's going to end up in undermining the ability of this committee to conduct legitimate oversight at the times when that's appropriate. So I've exceeded my time. With that, I yield back, and I thank the chairman.
The gentleman yields back. The gentleman from Alabama is recognized.
Thank you, Mr. Chairman. I yield to Mr. Armstrong.
Thank you. Couple things. One, I would be happy to argue this because and to my colleague from Maryland, I wish you'd have been here in May of 2019 because we legitimately, as the chairman said, we held the Attorney General in contempt after exerting privilege, but it was more than that. We held him in contempt for not violating the law.
Right.
Like, there's actually a statutory requirement that you can't disclose grand jury testimony. So if we talk about the path we're going down and continue in talking about oversight, we don't have to go back to Nixon. We can go to May of 2019. And so to my colleagues on the other side of the aisle that are arguing about this, I would love to get that transcript or audio or video and come back out here. But we're not duplicating a criminal proceeding. There is no criminal proceeding. We got the answer from where we're at. And if you talk about I'd argue this if we go in front of somebody and say, of course they're doing it. They're running out the clock. Like, he could have exerted executive privilege, I don't know, a week ago, a month ago, 6 weeks ago. It's a pattern that is going on with this DOJ and this White House, that as we come up to the precipice of when you're actually going to do something, then they say at the absolute last minute, they drop all of this. And we have a right to do these things. And I fully am aware that the difference between a criminal prosecution and a civil litigation and a congressional hearing are the same thing. But the basic premises of what is the best evidence, what we are entitled to versus what the opposing side says we are entitled to, is something I think the people on my side of the aisle are completely willing to have that conversation with whoever is an independent and neutral arbitrator of those facts.
Will the gentleman yield?
Sure.
You know, the best evidence standard, which I don't think is necessarily applicable here because it's not a court proceeding, and the demeanor evidence things, I think, fell on their face for the same reasons. But the point here, I think, though, is with respect to the 6E issue, it can be waived and routinely is as a matter of practice, and certainly has been for Congress. So, you know, I don't know that that's a real good analogy. But the bottom line here, though, is you guys are arguing you need it for demeanor evidence, which again has no applicability here because it doesn't go to the finding that came from her or the impeachment transcript. And really, this altering the transcript is really what you have to argue. In fact, the chairman argued that. But there's absolutely no evidence of that. In fact, it's a certified transcript. This isn't one that was somebody typed it up on the side. These are the transcripts that we generate on a routine basis in Congress and the Department of Justice.
Reclaiming my time, that's not my, that might be somebody else's argument. That's not my argument. My argument is if I have the version of going through something and dealing with something and all of those different things, I have watched witnesses in this committee in depositions say things because they know they've agreed to it not being released on video. How something reads and how something sounds is different. That is true. And I'm not arguing that I'm not saying what they're entitled and not entitled to give me. I'm saying I'm entitled to this evidence, and I think this hearing is entitled to it, and I'm willing to have that fight. I have never been in my entire life said, okay, you tell me what I get, and I'll just agree to that. And that's not the point. And regardless of all of the other issues, you don't get to say at the last minute, we're exerting executive privilege because nobody will ever come and voluntarily come into an investigation ever again, because if we release the audio recording instead of the transcript, that's gonna have a chilling effect. That is a ridiculous argument. I don't care what the burden of proof is, it's just a ridiculous argument.
Will the gentleman yield again?
Yeah.
I mean, that's an argument that's been raised administration after administration after administration, including by the Trump administration on multiple occasions. The assertion of executive privilege is at least 50 to 60 years old. And that is based on a decision by the executive branch, usually the Department of Justice, to make a decision as to what they'll turn over and what they won't. And if it has to get litigated in court, then the court decides. But this is exactly how it's supposed to go.
Except executive privilege is usually done whether or not you get the information or not. I was here, I remember when the Attorney General came in and said, I can't turn this stuff over because I will be breaking the law. This isn't a matter of whether they're turning it over or not. We already have whatever you think it is. They're saying, we're only gonna give you the piece of it we wanna give you. We're not gonna give it to you, give you what you guys want. And that's the fundamental disagreement that exists here. We want the evidence of what happened, and the best evidence available is the audio tape. And with that, I yield back.
Gentleman yields back. Gentleman from Alabama yields back. The gentleman from Tennessee is recognized.
Thank you, Mr. Chair. I have been despairing the state of our country, but even more so the state of this committee and the judiciary for the last several months. This committee is becoming the Eileen Cannon Committee, the Trump-anointed group to support him and defend him for conduct that is not defensible and to put roadblocks in the path of justice where he should be on trial in Florida for his keeping classified records. He didn't declassify them, he just kept them. This is a man who several of our colleagues went to New York and said that our rule of law was false, that this case in New York was political and shouldn't have taken place. The thing we're most respected for around the world is the rule of law. People envy us for our rule of law. And to have people who know better go and trash it is despicable, almost treasonous. And then this committee, the hypocrisy that this committee would question Merrick Garland, who appointed a Republican to look into President Biden's conduct, a man who Mr. Hurst said, and he was here to be questioned, anybody here could have questioned him about the conduct of what Mr. Biden said and why he came to that conclusion, but he said he was a sympathetic elderly man with a poor memory. The fact that he was sympathetic is why he would not be convicted, as distinguished from his forthcoming opponent and past opponent, who is a despicable, mendacious man with a poor knowledge of history and government and a poor memory to boot. A man who his own Secretary of State said was a moron. Yes, Tillerson said he was a moron. Kelly said he admires, John Kelly, his chief of staff, said he admires autocrats and dictators and has no conception of the rule of law or concern for it or for democracy in our country. His defense secretary, Mark Esper, said he was a threat to democracy. John Bolton declared him to be unfit to be president. And of course, Mike Pence said they had profound differences. All folks coming up here and defending what's going on in New York. This is a man who had just, his wife gave birth to his child, and he was playing golf and fornicating in Nevada rather than being with his wife and his newborn child. What an example we have for the American public and for young people. Joe Biden is, as Colin Yost said at the correspondence dinner, a decent man. He's sympathetic and a decent man. And the idea, one of the gentlemen said, we're in an impeachment hearing. We're not in an impeachment inquiry. These are just things they've thrown out there to try to take the facts away that he was twice impeached and to try to impeach
Would the gentleman yield?
Biden and Mayorkas. Both were wrong. And the hypocrisy that almost, I think every Republican on this committee voted against holding Barr in contempt, and that one of our members, my friend, the chairman, was cited for contempt because he refused to appear before a committee dealing with January 6th and the overthrow of the government. The hypocrisy is voluminous, and I yield to Mr. Nadler.
I thank the gentleman for yielding. I just want to point out that the discussion we heard before about best evidence and so forth between Mr. Armstrong and Mr. Ivey is fit for a criminal trial. But this is not a criminal trial. This is a dispute between the executive branch and Congress. And in such a dispute, Congress must show a need for the evidence that we seek. Republicans have not made that showing. They've shown no need for these files. So the discussion we heard before is irrelevant because it was dealing with a criminal trial. This is not a criminal trial. This is a dispute between the executive branch and Congress. And in such a dispute, Congress must show a need for the evidence that they seek. Republicans have not made that showing. They have not shown any need for these files, and that renders this whole thing ridiculous. And I thank the gentleman for yielding, and I yield back to him.
Thank you. In my last 10 seconds, all I can say is, God bless America, because we need somebody of that authority to bless us with the way this committee and these folks have dealt with this case and ruining a constitution and democracy.
Gentleman yields back. The gentleman from California is recognized.
Thank you, Mr. Chairman. Since the discussion has drifted into the Manhattan trial, I just have to say that it's ironic to hear my colleague from California speak to the integrity of our legal system Like most Americans, I am appalled that our justice system could become so dangerously politicized. It started with the IRS harassing members of the Tea Party years ago. Then we had the FBI and intelligence agencies using what they knew was a completely fabricated story by the Clinton campaign over Russian collusion. My colleague played a large role in that and was censured by the House for his role in it. Then we had the intelligence agencies concoct a lie that the Hunter Biden laptop was a Russian hoax, and that may have decisively affected the outcome of the 2020 election. And now we have these sham cases against Donald Trump on the flimsiest of legal grounds that have never been charged before, and with the obvious intent to interfere massively with the presidential campaign. The sinister nature of these cases is that it doesn't matter that they're falling apart. That's not the point. The point is to drain Trump of his time and resources and throw the election to the Democrats. Now, the cornerstone of our justice system is equal justice under law, that no matter who we are, we're treated the same. That's why justice is depicted as blindfolded. And in each of these cases, there seem to be three standards of justice, one for Donald Trump, one for the rest of us, and then one for the Democrats. And that strikes at the heart of the matter before us, the decision to prosecute Donald Trump for mishandling classified documents and the decision not to prosecute Joe Biden for the same offense. Now, executive privilege is an important concept, has an enormous bearing on the separation of powers. The discussion, in fact, it goes back to George Washington's administration. And the discussions that a president has with his advisors or subordinates in the executive branch on any matter within the powers of his office are no more the business of the legislative branch than the discussions among members of Congress are the business of the executive. The president cannot compel Congress to divulge its deliberations any more than Congress can compel the president. So it's crystal clear to me that any official discussion between the president and any subordinate cannot be pierced. But this case is very different because it's not a conversation between the president and a subordinate over policy or the discharge of his official duties. Rather, it's an interview in the course of a criminal investigation. To me, this is far closer to the Nixon tapes. The Nixon tapes were not conversations as part of a criminal investigation, but conversations that had bearing on one. The conversation in this case is even further from the root of the executive privilege. This was an interview in a criminal investigation that clearly falls within the legitimate legislative function. It's not only a legitimate inquiry, it's a vital inquiry. How is it that there are two cases involving the handling of classified information that have been treated so radically differently? As President Donald Trump had absolute authority to declassify material at will, as Vice President, Joe Biden did not. Under the Presidential Records Act, President Trump had absolute discretion to determine what papers to retain in the course of his presidency. As Vice President, Joe Biden did not. And yet a decision was made to prosecute Donald Trump and yet not to prosecute Joe Biden by the Joe Biden administration. So it bears repeating, the foundation of our judicial system is equal justice under law. Without this, the law loses its moral authority. It simply becomes raw political force. And it's apparent to me that we are moving dangerously away from this principle of equal justice. Congress has an essential role to play in setting things right before we lose the very principles that define us as a free people. And central to this is to understand why these two cases were treated so very differently. The request of the administration is legitimate, and the contempt citation for its refusal to provide this information is entirely appropriate. And with that, I yield back.
Well said. The gentleman yields back. The gentleman from California. I have California, then I'll come there. The gentleman from California, Mr. Lewis, recognized.
Thank you, Mr. Chairman. The House Judiciary Committee is responsible for helping to ensure the rule of law. Unfortunately, the actions of this committee chairman in ignoring a bipartisan congressional subpoena has hurt the ability of this committee to get information and hurt the rule of law. It is a height of hypocrisy for the chairman of this committee to try to enforce a contempt subpoena against Merrick Garland when this chairman himself ignored a bipartisan congressional subpoena. Now, I've been to a number of proceedings in my time in Congress and in the state legislature that have been relatively stupid. But this proceeding goes beyond stupidity. It is a waste of taxpayer resources. Why is that? Because we have their transcript. We have the transcript of the interview between Special Counsel Robert Hur and President Biden. There's no evidence whatsoever that this transcript was made up, that it's fake, that it's been doctored. This transcript was produced by Robert Hur's office. Robert Hur was appointed by Donald Trump. He is a Republican appointee. The notion that somehow this transcript is fake is a wild, insane conspiracy theory. You know what I think is really going on? Joe Biden stutters. He's always had a stuttering problem. He was made fun of as a child because he stuttered. He was bullied as a kid because he stuttered. He overcame stuttering to become president of the United States. And Republicans in the past have used his stuttering to smear him. I think that's what they want to do again with this audio. I think that is despicable. And if Republicans are going to go low, I am going to punch back. So let's talk about Donald Trump. I agree with the Republican from New Jersey who said if a person cannot stand trial, he should not be president of the United States. Donald Trump has fallen asleep multiple times at his own criminal trial. I am a former prosecutor. I can tell you that is not normal. I think there may be some physical and mental health issues that should be investigated. I'm going to tell you what people in the courtroom are writing about Donald Trump falling asleep. Here's a reporter who has been observing this. One reporter observed, quote, that Donald Trump has nodded off a few times, his mouth going slack and his head drooping onto his chest, end quote. Another reporter said, quote, that Donald Trump slowly dropped his head. His eyes closed, it jerked back upward, he adjusts himself, then his head droops again, he straightens up, leaning back, his head droops for a third time, he shakes his shoulders, eyes closed still, his head drops, end quote. If a person is so weak and feeble, if Donald Trump is so weak and feeble, he cannot stay awake at his own criminal trial, he can't be president of the United States. So instead of going around trying to smear different people, why don't we work on a bipartisan basis on issues that matter to the American people? Like, how about let's do a bipartisan hearing and let's do some bills to fix our broken immigration system. But the Republicans here don't want to do that. They don't want to work on a bipartisan basis. They don't want to fix this. Why? Because Donald Trump told them not to. Well, okay, so how about another issue? Let's talk about high prices. Prices are high. We did get a good report yesterday that inflation has now slowed down. That is good, but prices are still high. Why don't we work on bipartisan basis to look at price gouging? We have companies making record profits. They're gouging consumers. Let's have a hearing on that. Why don't we have a hearing on that? Because Republicans don't want to fix this issue. They want it as a campaign issue. Okay, then how about let's do a topic that isn't a campaign issue. Artificial intelligence has now become prevalent in many places. It could have privacy implications. It could do amazing things. It could also harm us in a variety of ways in terms of bias and so on. Why don't we do a hearing on this in this committee? Why don't we do that? Instead, we're here doing this stupid stuff to try to get audio of a transcript we already have. And it gets even worse than that. There is a second committee. The Oversight Committee is going to do an exact same hearing on this contempt proceeding. Let me just put in that, you know what, at least the chairman of that committee did not ignore a congressional bipartisan subpoena. It might be more appropriate for that committee to do it, and we should end this proceeding right now. I yield back.
Gentleman yields back. The gentleman from Texas is recognized.
Thank you, Mr. Chairman. After that 5 minutes, I was starting to get a little sleepy. I would like to yield my time to Mr. Vandrew.
I thank the gentleman for yielding. Man, here we go again. So the gentlemen, my friends from Tennessee and California and Maryland, they want us not to have our eye on the ball. They want us to look, and we talked about this before in this committee, the shiny object over here. When you're really in trouble on the other side of the aisle, when you've really got a problem, let's go after Donald Trump. Let's make it a campaign stump speech. Let's talk about what a bad guy is. Let's talk about all these different issues. That's not why we're here. That's it. Again, if we want to have a separate debate, a colloquy, a discussion, formal, informal, we'll do it, man. I'm ready to go at it. I think most of us here are. But that is not the issue. The issue is this committee feels that it needs an audio transcript because the charges, the concerns are so serious. I want everybody to understand, we're either saying that our current president is cognitively impaired, incompetent, unable to stand trial, even though he broke the law. So the Department of Justice decides that they won't go after him for those reasons. And if that's true, we need to hear the audio tape. You're going to be able to understand if he truly is that cognitively impaired, if he truly has those problems, if he cannot deal with these issues, if he didn't know what he is doing. We are going to learn a lot more. And by the way, if it's no big deal, as the other side says, because we have the transcripts, well, we do have the transcripts, so why do you care so much about us getting the audio? What's the big
Would
deal?
the gentleman yield for an answer?
I just want to finish this first. I will yield. We already have the transcript, so why don't we have the audio? Because we can find out whether he is in that much trouble, if the country is in that much trouble. This has got nothing to do with what's going on in New York. This has to do with what's going on right here in the White House in Washington, D.C. with this president. Or if he is not cognitively impaired, if he is with it, if he is capable, then he broke the law as vice president and as a U.S. senator, not allowed to take these classified materials out, kept them in a garage by his home next to a collapsed dog kennel, and then used them. I want everybody to understand that. Then used them, read them to his ghostwriter to use in his multi-million-dollar book deal. Was he competent? Did he know what he was doing when he made this deal and used these papers to make money on the presidency? That's what we need to know. That's why we're going through all this. It's got nothing to do with the other stuff. And that's what we need to find out.
The gentleman yield now.
And that's why, I will, in one moment, and that's why we're having this discussion, because this committee has an oversight responsibility and needs to know that. But it's not only the committee. Most importantly, the American people need to know it. We need to know if we have an incompetent, incoherent president, or if we have a president that is being helped through the two-tier system of justice, again, just like they tried to help his son. Justice for thee, not for me. God help us, the American people, whomever are watching and listening to this, don't have those opportunities, but he keeps getting them over and over again. Which is it? I know it's a bad spot for you folks. I get it. It's a really uncomfortable place to be. But we need to find out the truth. And I yield to the gentleman from Cal. Actually, I'll yield to you, the gentleman from California.
Thank you. I just want to comment the following. The special prosecutor decided that there was no reason to prosecute for his own good reasons. He stated them in his report. He made what I regard as a gratuitous smear of the president by his comment on cognitive impairment. We will see. We don't need the transcript to see if the president is cognitively impaired. The president speaks all the time. There are going to be two debates. The American people can decide whether the president is cognitively impaired. They can decide whether his opponent is cognitively impaired. They're going to see plenty of evidence of that in the debates and in the campaign. So we don't need the transcript to know whether the president is cognitively impaired or not. The evidence is going to be before the American people.
I reclaim my
thank the gentleman for yielding.
I reclaim my time. And look, this doesn't have anything to do with the debates, though. I get it, and I know everybody's going to enjoy them, me included. But this has to do with the actions that took place regarding classified materials. And either, as the special prosecutor said, he is cognitively impaired and unfit for trial, or he knowingly did this and made money off of it. I yield back to Mr. Nels. I think Mr. Nels yields back to you.
Gentleman yields back. The chair recognizes the gentleman from Georgia.
Thank you, Mr. Chairman. This hearing is a continuation of what this Congress has been about under Republican authority since January 3rd of 2023. We started out trying to elect a speaker. It took, I think, 19 ballots before this Congress, back in 2023, January, was able to elect a speaker. And then that speaker presided over what is agreed upon by most people who are observing this committee's functions this Congress's functions. This has been the least productive Congress in the history of the country, many are arguing. And my friends on the other side of the aisle on this committee are a part of that. They have spent $20 million investigating President Trump. This committee alone has spent $20 million during this 118th session of Congress, which began in January of 2023, investigating President Biden. They suffered the indignity of their leader, former President Trump, being indicted for withholding classified documents. That indictment was in July of 2023, during the height of this do-nothing Congress, and not long before this Congress expelled the Speaker. It took so long to elect in January. They put him out in October. And then we went for 3 weeks while even people on this committee were vying for the speakership. It took 3 weeks and ran through a number of candidates before this Congress elected Mike Johnson as its speaker, formerly of this committee. And he has not fared much better. Neither has the House under his reign. Still nothing accomplished, and we get to this point now where after spending $20 million, this committee has absolutely nothing to show for it. They tried to pin a classified documents case on President Biden. They had a special counsel Herr, who spent a lot of money investigating, couldn't find a thing, had to write a report that cleared the president from illegally withholding classified documents. And then he was summoned to this committee to deliver the findings of his report, which included a derogatory reference to President Biden being having a loss of memory, disparaging him. And that was the only thing that Republicans could get out of Herr's report. And so they made hay of that for a while, and then that went away, and now it has come back. We're seeking to hold the Attorney General in contempt of this committee for refusing to produce an audio file. When you already have the voluminous document, the entire unredacted Herr report, the transcript of the interview with the president, even talking to the president's ghostwriter. It was an exhaustive investigation. And the only thing we can do now is come up with additional information to show that Biden is cognitively impaired. That's what this committee is trying to do today, according to my friend from New Jersey, get the evidence that Biden is cognitively impaired. So this is political. It's a do-nothing Congress. It's the product of a do-nothing committee. The American people deserve more, and they're seeing what's happening. And I think they're going to sweep this committee out of its perch, and Democrats will be back in control so that we can do the work that the American people need us to do, to keep them safe and to make sure that costs are down, make sure that our economy is humming along, jobs, rebuilding America. That's what this committee needs to be about, not a fishing expedition trying to show that this president is cognitively impaired. And with that, I yield back.
Gentleman yields back. The gentleman from Wisconsin is recognized.
Thank you, Mr. Chair. I mean, a lot of us sit here when we listen to the special counsel, I think, respond to many questions that day, sitting right there in front of us. And I began to wonder kind of what were the conversations behind closed doors? What were the discussions amongst the attorneys on how are we ever going to dismiss the idea that the President of the United States holding substantial positions within our government had absolutely secured on his own person sensitive documents and then was able to take them back to his residence, move boxes of them to offices in multiple locations, and obviously willingly and knowingly mishandling secret, sensitive U.S. government documents and just dismiss this. And there had to have been a conversation with the special counsel behind closed doors about, well, let's see, they just did a raid on the former president's home in Florida, lights going, securing specific areas of that residence, and really kind of ransacking the place. And now we find out, probably, a little bit of orchestration on what they wanted those documents to look like when the photos were taken. But I can't imagine what the special counsel and his assistants were trying to dismiss by simply saying that the president, he's not all there. And we've seen it on TV. We see it every day now. He's completely incompetent from handling a simple press conference. So that became their way out. That became what they thought could justify letting him off the hook. And I'm not sure where that would have gone as a criminal prosecution. None of us are ever going to know that, right? I mean, my own personal opinion is that Herb blew it, because he's the one who set up this juxtaposition of the President of the United States, who, by the way, just agreed to 2 presidential debates, okay? But at the same time, we're supposed to believe that, he had a few boxes in the garage and he lost track of them, and he's just not up to standing trial for this. He's just not up to actually having an attorney ask him poignant questions about what he was doing with the documents. And was he aware what were in those boxes that he had all over the place? And now, today, we get a letter from Mr. Siskel. So again, I wonder what was going on behind closed doors at the White House yesterday in the discussions on how are we now going to make sure that we protect the president again from having to disclose anything of substance. And the paragraph that strikes me is, the absence of a legitimate need for an audio recordings lays bare your likely goal. Now they're telling Congress what our goals are in trying to secure evidence. And that is to chop them up, distort them, and use them for partisan political purposes. Okay, and that's not part of our process either, right? That you have to run for re-election. So if something like this was actually utilized in that way, which that is not the committee's intent, but clearly one of the attorneys over at the White House dropped the ball when they wrote that paragraph. Because it just went from us not being able to do oversight to now we've come up with a way that we're actually going to execute a little bit of a cover-up. We're going to move towards cover-up to make sure that the special counsel's conclusions are not questioned beyond what was done in this room when he was here a month ago. So, Mr. Chairman, this entire day is not only warranted, but the American people see what's going on here. We're not going to elect Donald Trump. The other side of the aisle in the White House is going to elect Donald Trump. And I yield back.
Gentleman yields back. The chair now recognizes the gentleman from California, Mr. Swalwell.
Well, it's nice to see that some of my colleagues on the other side could make it today. I don't know if that means that there weren't enough seats in the courtroom in New York, but I know that the Oversight Committee canceled a hearing that was supposed to happen right now on this matter so that they could be at the president's trial. I know some members will miss this vote because they want to be at the president's trial, and I don't think that anything could animate the phrase, "do nothing Congress," more than missing votes and canceling hearings to go up and be a spectator at your cult leader's trial. That is the definition of do nothing Congress. But I'm here for a celebration because, let's raise a glass, it's been about 2 years this week. May 12 is when Jim Jordan, our chairman, was subpoenaed and asked to comply with his subpoena for his role, his interaction with the former president on the January 6th attack of the Capitol. And so we are now 735 days in. It's 2 years, and this committee has the nerve, this committee has the temerity to seek compliance from the Attorney General. I actually think you should not be able to bring any subpoena of another person if you are out of compliance of your own subpoena. That seems to make a lot of sense to me, and we'll have an amendment to address that a little bit later. But I want to talk about this particular effort to hold the Attorney General in contempt, because what is this really about? After all, it was Donald Trump's appointed prosecutor who the Attorney General deputized to be the special counsel here to look at President Biden's handling of classified documents. So it was Donald Trump's prosecutor who cleared President Biden. He said, there's nothing to see here. And in fact, although he did not put it in the lead memo for his report, there was an exchange that he acknowledged in the interview with President Biden where the special counsel told the president, your recall is photographic. He didn't say your recall is good. He didn't say your recall is decent. The special counsel said, your recall is photographic. So what is this really about? This is about you all not accepting the outcome of the 2020 election. You rooted on the rioters as they sought to attack the Capitol on January 6th. If that wasn't enough, you all went back to the floor and relitigated the issues that brought the rioters to the Capitol just 8 hours later. Many of you go and visit the convicted criminals who assaulted the police officer at their jail cells. And during Police Week, as a bunch of officers yesterday testified in the Homeland Security hearing that those officers are heroes and those rioters are criminals, you call them hostages. And the former president calls them hostages. So this is entirely about not accepting the outcome of the January 6th vote here, rooting on the rioters, and doing everything you can to try and affect the outcome of the upcoming election. And so then I thought to myself, is there like a parallel? Is there another investigation where your side was completely incurious about what that investigation yielded? Turns out there was. Turns out it happened recently. Turns out somebody on your side was investigated for sex trafficking. Now you're going to say, well, he was cleared. They dropped the charges. Yes, the Biden Attorney General dropped the charges, didn't pursue, didn't bring charges. That's exactly what happened with President Biden. But you all have shown no interest to go to the Attorney General and say, well, we want to learn more. We want to see the notes and the audio recordings and the evidence of our own colleagues' sex trafficking investigation. Not a peep from any one of you. So if you wanted to do that, if you wanted to show just a little bit of consistency, I would be willing to entertain that you have a genuine interest in understanding what happened in that hearing. But that's not what this is about. This is about doing everything to help Donald Trump, who you see as your client, who a New York criminal trial sees as a defendant, to help him win an election. So I have no interest in playing this game. The American people have no interest in playing this game. And all this does, for those of you who have graced us with your presence, animates that it's a completely do-nothing Congress. And I yield back.
Gentleman yields back. Gentleman from Texas is recognized.
Thank you, Mr. Chairman. I'd yield to the gentleman from California.
I'll be very brief before my colleague from California leaves. I've been on this committee long enough to know why we mark up contempt. This committee and the committee that he referred, Oversight, we've held people in contempt for not doing things. This committee successfully held in contempt the chief counsel to the president under George W. Bush for not showing up. We, next door, held in contempt Eric Holder for withholding information that he said he had 200 and some pages. Ultimately, over 10,000 pages turned out to be delivered. What's interesting and very similar is the president's old boss, President Obama, claimed executive privilege on exactly the day we were about to do this. And ultimately, none of those 10,000 pages stood the test under a judge appointed by President Obama for executive privilege. So the false claim of executive privilege today is just as much a ruse as it was under President Obama. And that's the piece of history that I hope my colleagues will observe as we hold this Attorney General in contempt. And I thank the gentleman for yielding.
Yeah, I thank the gentleman. I mean, I would note that my colleagues are decrying the fact that some of our colleagues are in New York. But let's remember what's happening in New York. I mean, we have a clear sham trial being perpetrated by a judge with clear bias. We have a situation where the entire thing relies on Michael Cohen, who, I mean, just to say the least, is a convicted felon, has been disbarred, has pled guilty to perjury and various financial crimes. The judge, his own daughter, is a known Democrat political operative, has clients, including some of our Democratic colleagues, I think even on this committee, including some Democratic colleagues who are in fact advising Michael Cohen at this particular moment. All of that is occurring at a time when they're calling Michael Cohen when they could bring forward Alan Weisselberg, who is sitting over in Rikers, but for some reason they're not bringing him forward, which one could guess because it wouldn't help. And the fact is, this is all playing out while bootstrapping a federal law into a state crime in order to try to navigate statutes of limitations. It's ridiculous. I mean, it's patently absurd what we're seeing unfold with our system of justice, the politicization of it. And now here we sit, and my colleagues on the other side of the aisle don't like that we simply want to see the best evidence available when in fact it is not, as one of my colleagues talked about, trying to effectively get a second stab at criminal proceedings. This is an impeachment inquiry. That is inherently not a criminal proceeding. It is a unique function of Congress under the Constitution of the United States. And we're investigating very legitimate questions, conflicts of interest of the Biden family, the significant amount of money that has flowed to the Biden family, the extent to which the president has had material that he's not supposed to have in his possession, which the special counsel firmly pointed out, and in fact, in this committee, testified to. And in fact, the president and his lawyers have contested Special Counsel Hur's assessment. But the truth is, Special Counsel Hur in this committee stood behind his sworn testimony. We've got evidence that we can see in transcripts, but all we're pointing out is it is a both impeachment function and legislative function of this body to be able to use the power to be able to go to the Department of Justice, which is supposed to be overseen by us in the first place, by the way, and to say, we simply want to see the best evidence because if you look in the terms of the criminal proceeding, which is not an impeachment inquiry, and is not the legislative function. It is an independent, unique function in the criminal inquiry that they're carrying out at justice. That clearly what you saw from Special Counsel Hur was a great deal of dependence on the demeanor of the president. An extraordinary amount of dependence in terms of his determination on whether to pursue charges depended on how he assessed the demeanor of the President of the United States. That's all this is about. It's not political. It's not about something that might show up later for political purposes. It is very much to the heart of whether or not and what the president knew about the materials that he had, which the special counsel firmly acknowledges and wrote were illegal for him to possess. And the question is what was his intent? And it is critically important for the purposes of this body to determine where we're going to go with an impeachment inquiry or any legislative inquiry to determine what the president's demeanor was during that interview. I yield back.
Gentleman yields back. Gentleman from Virginia is recognized.
Thank you, Mr. Chairman. You know, I'm disappointed. Moved to strike last word.
Was recognized.
I'm disappointed, but I'm not surprised that we're getting a letter from the White House citing executive privilege the day before the hearing, the day before the markup. And as my colleague from California knows, who's the ranking member on the subcommittee that I chair, Responsiveness and Accountability to Oversight, this is common behavior for this White House. Wait until the last minute and then throw either an excuse or a few pages of documents that have been subpoenaed, much of which is publicly available, to us to try and fend off exactly this, a contempt citation for failure to comply. You know, it'd be one thing if it were the subcommittee that I chair. It'd be one thing if it were documents subpoenaed at the Department of Health and Human Services or Education or the FTC about collusion with big tech, about the COVID information that they tried to limit availability on the internet. There are so many different ways in which this administration has failed to be accountable, failed to be held accountable, and failed to provide the information that we've requested, that we're not surprised. But this is under an impeachment inquiry. Last year, we approved an impeachment inquiry in this body, which heightens that standard and actually increases the burden on the administration to show that there is some reason why they should not be providing this information. And executive privilege is not applicable here. We have a request for a recording. As was stated earlier, the White House doesn't get to decide how that information is provided, which transcript is better, which transcript is appropriate. If we want one transcript, they give us that one. If we want the other one, they have to give us that one. This investigation is about whether the president willfully retained and disclosed classified materials after his vice presidency when he was a private citizen. Actually, that was a conclusion. And then Hur's investigation also concluded that Vice President Biden had, quote, strong motivations, unquote, to ignore the rules for properly handling classified materials. Those strong motivations included an advance of $8 million that Biden had planned to receive for writing his memoir, a book he had decided to write, quote, months before leaving office. But why has the DOJ not sought to bring charges against the president for his actions, both as vice president and a private citizen? Well, for one reason, Special Counsel Hur noted in his report that although there was sufficient evidence that Biden had willfully retained classified information, he wouldn't recommend taking it to trial because the president would appear to a jury to be, quote, sympathetic, well-meaning, elderly man with a poor memory. But Hur knew that to make the $8 million book advance, he would need reminders. but many of those reminders are classified, and yet he shared them with his ghostwriter, Mark Zwaniter, who holds no security clearance. As part of the impeachment inquiry in the Judiciary Committee's legislative oversight, the committee has sought information about, among other things, President Biden's mishandling of classified information. And the DOJ refuses to provide the committee with these recordings. And Attorney General Garland not only confirmed that this material has been turned over to the White House and not us. He said this during an appropriations testimony, but failed to see the hypocrisy in allowing the White House access to these recordings, but not the Judiciary and Oversight Committees. So he rejected the notion that DOJ should release the recordings and said they needed to remain confidential, but at the time had no response as to how to provide the recordings to the White House, as to how he provided the recordings to the White House. So these recordings are important to our investigations because of the superior evidence that the transcripts, the recordings provide, because transcripts do not capture demeanor evidence. And there's evidence that the White House has doctored official transcripts to hide a verbal slip-up from President Biden already. So if they're already doctoring official transcripts, we need the tapes. We need the tapes, and they have an obligation to provide them to us. I yield back.
Gentleman yields back. The question occurs on the amendment offered by the gentleman from New York. Those in favor say aye.
Aye.
Those opposed, no.
No.
Opinion of the chair, the noes have it, and the amendment is not agreed to. The roll call being requested, the clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Bishop? Ms. Spartz? Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Mr. Moran votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Bush? Mr. Ivey?
Aye.
Mr. Ivey votes aye. Ms. Ballant? Mr. Issa, you're not recorded. Mr. Issa votes no. Mr. Fitzgerald votes no. Mr. Gooden votes no. Mr. Fry votes no. Mr. Chairman, there are 8 ayes and 17 noes.
The noes have it, the amendment is not agreed to. Gentleman from Georgia.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from California.
Amendment to the amendment in the nature of a substitute. To
Objection, the amendment will be considered as read. The
I
gentleman.
object, Mr. Chairman.
Okay. Clerk Clerk will read the amendment.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find Merrick v. Garland in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on the Judiciary, offered by Mr. Johnson of Georgia. On page 13, at the end of the second full paragraph insert, the committee also notes serious concerns about the competency of Donald Trump. The weekend before the committee took up this contempt report in a speech delivered in Wildwood, New Jersey, Mr. Trump praised the fictional serial killer from Silence of the Lambs, quote, the late, great Hannibal Lecter, he's a wonderful man, unquote, and, quote, congratulations, the late, great Hannibal Lecter. We have people that are being released into our country that we don't want in our country, end quote. Mr. Trump also confused the Chinese city of Beijing with the self-governing island of Taiwan and confused the famous tennis player Jimmy Connors with President Jimmy Carter. At a rally in Iowa last January, Mr. Trump declared, think of it, magnets. Now, all I want about magnets is this. Give me a glass of water, let me drop it on the magnets. That's the end of the magnet. During a series of March campaign rallies, Trump mistook the country of Argentina for a person telling the crowd, you know, Argentina, great guy. He's a big Trump guy. He loves Trump. I love him because he loves Trump. Anybody that loves me, I like them. He also claimed that a poll was a legislative bill called our country the United Stage and made a series of unintelligible noises when describing himself. Ding, boom, this is me, unintelligible, bing. It is not even clear if Mr. Trump knows which of his political opponents he is running against. Mr. Trump has mixed up President Joe Biden and former President Barack Obama on at least 8 different occasions. He confused presidential candidate Nikki Haley with former Speaker Pelosi, inferring that Ambassador Haley was responsible for Capitol security. Mr. Trump has also been confused with respect to foreign leaders. For example, in October 2023, Mr. Trump referred to Hungarian Prime Minister Viktor Orban as a great leader of Turkey. These examples and more raised serious concerns about Mr. Trump's mental competency and ability to serve another term as president.
Gentleman is recognized.
Thank you, Mr. Chairman. Mr. Chairman,
The gentleman.
This contempt report that is being considered today is chock full of misleading references to President Biden's age and his mental competency. And throughout this hearing today, I've heard the false allegation made that Special Counsel Hur found that Biden was incompetent to stand trial. That is not what Hur found. He simply questioned the president's memory. And so let's not get it twisted. And speaking of, cognitive impairment, the report that we're considering today conveniently omits serious evidence that the standard bearer for my friends on the other side of the aisle, Donald Trump, is the only candidate who shows any evidence of competency problems. Just this past weekend, in a speech in Wildwood, New Jersey, Mr. Trump bizarrely praised a fictional serial killer from Silence of the Lambs, the late, great Hannibal Lecter. He's a wonderful man, is what the president said. And congratulations, the late, great Hannibal Lecter. We have great people here that are being released into our country. We don't want our country. We don't want in our country. Hear it for yourself. Play the tape.
Silence of the Lamb. Has anyone ever seen the Silence of the Lamb? The late, great Hannibal Lecter. He's a wonderful man, President Xi of China, talking about Beijing. Now, they've got ships circling, they have planes, but they never were doing anything. I could have pressed Hillary a lot harder. You know, she broke up her phone, she broke them up, she acid washing. Bit bleach, right? Bit bleach. Nobody even knows what it is. All done by Biden. Carried out by Ray. That's right. Jimmy Connors is good. He's also happy. Congratulations, the late, great Hannibal Lecter. We have people that are being released into our country that we don't want in our country. I'm up here screaming like a lunatic.
Ladies and gentlemen, that sad display took place just this past weekend with the former president. He appeared to confuse the Chinese city of Beijing with the self-governing island of Taiwan. He confused Jimmy Connors, a famous tennis player with Jimmy Carter, the 39th President of the United States.
Would the gentleman yield?
No, I won't. This rant is not a singular event. Last January at a rally in Iowa, Mr. Trump incoherently stated, quote, "Think of it, magnets," end quote. And now all I know about magnets is this: give me a glass of water, let me drop it on the magnets, and that's the end of the magnets, end quote. During a series of March campaign rallies, Trump mistook the country of Argentina for a person, telling the crowd, quote, "You know, Argentina, great guy. He's a big Trump guy. He loves Trump. I love him because he loves Trump. Anybody that loves me, I like them," end quote. He also claimed that a poll was a legislative bill, and he called our country the United Stage, and he made a series of unintelligible noises when describing himself. Ding, boom, this is me, bing. It's not even clear if Trump knows which of his political opponents he's running against. Mr. Trump has mixed up President Joe Biden and former President Barack Obama on at least 8 different occasions. He bizarrely mixed up presidential candidate Nikki Haley with former Speaker Pelosi, inferring that Ambassador Haley was responsible for Capitol security. He can't keep straight the names of world leaders. In October of 2023, Mr. Trump referred to Hungarian Prime Minister Viktor Orban as the, quote, great leader of Turkey, end quote. Republicans are intellectually and morally dishonest to criticize President Biden when their dear chosen leader, Donald Trump, presents with symptoms which are quite frankly scary. The American people can see through this Republican charade. This is just an ugly exercise to hurt President Joe Biden. Let's move on. And with that, I yield back.
Gentleman yields back. Gentleman from Kentucky is recognized.
I just wonder if the gentleman from the other side of the aisle is concerned that the additional aid that was voted on to go to Taiwan would cause that island to tip over in any point in the future.
You know what? I hope that
the
island of Guam is floating on water and not on diesel fuel. That's the point I was making.
Well, this is...
And I think that the gentleman might question my mental acuity, but let's look at your dear leader. Let's look at your
reclaiming my time.
Time belongs to the gentleman from
Trump. Let's look
Time belongs to the gentleman from Kentucky.
Reclaiming my time. I have the utmost respect for my colleague on the other side of the aisle. The point I wanted to make is that sometimes we make statements tongue-in-cheek that we are metaphorically speaking, and that the president most certainly in most of those cases was doing that, as we all have, Republican and Democrat, made statements that if you're taken out of context seem indefensible or ungrounded, if you will. Let me give an example. So the comment on the magnets here, if you give me a glass of water, let me drop it on the magnets at the end of the magnets. I've actually heard the former president, talk about that, and what he's talking about are electromagnets. So there was a discussion about whether the catapults on aircraft carriers should be steam-driven or electromagnetically driven. And it is true that steam is more reliable, that water would not affect the hoses, for instance, but salt water could affect wires that are driving electromagnets. So I think it's disingenuous here to offer this and take many things out of context, to take things that were said tongue-in-cheek, to take things that were said on the campaign trail and act as if they were meant to be taken literally, because we all, on both sides of the aisle, have said things before that were not meant to be taken literally. And with that, I yield back.
The gentleman yield?
I'll yield, Chairman.
I thank the gentleman for yielding. I think the point is well made. You know, no human being's ever said everything exactly right. We've all made mistakes, whatever. But the fundamental question in front of us is, was the decision not to prosecute consistent with the Department of Justice's commitment to impartial justice? That's the fundamental question. President Trump is getting prosecuted for a classified documents concern. Joe Biden isn't. Biden isn't because, this is what the special counsel said. He said, Mr. Biden's memory appeared to have significant limitations, both at the time he spoke to his monitor in 2017 and as evidenced by their recorded conversations, and today as evidenced by the recorded interview with our office. That's why we want the audio tape. President Trump is the department being impartial. President Trump is getting prosecuted. We know what's going on in Miami. President Biden isn't, and he isn't because of that statement from the special counsel. That statement from the special counsel in light of the facts of the case. The elements of the crime have been met. Mr. Hur sat right at that table and told us Joe Biden knowingly kept classified information and knowingly disclosed classified information. Special counsel told us in his report why Joe Biden did it. He said he had strong motivations to release classified information because he was writing a book for which he got paid $8 million. So we have motive, we have the elements of the crime, but he doesn't get charged, and yet President Trump does. And so this committee, the committee that oversees the Justice Department, has oversight of the Justice Department, wants to know if they are impartially administering justice. And the best way for us to figure all that out is to get all the evidence that the special counsel had at his disposal so we can figure that out and see if there's something we need to do legislatively to change the special counsel statute. But it's all part of our oversight. That's the fundamental question. We can get into things people say. I've said things that, taken out of context, Mr. Massey has, Mr. Johnson has, we've all said it. So that's not the point. The point is that fundamental question. Was it the administration of impartial justice? Were they being consistent? That's what we want to know. I yield back. Thank you, John, for yielding.
Yield the remainder of my time to Mr. Tiffany.
Yeah, and just to add on to the chairman's comments in regards to impartial, I mean, if you go back to the Senate confirmation hearing for this Attorney General, he said, I'm going to conduct justice without fear or favor. And he's getting a chance now to live up to those words. Will he provide impartial justice without fear or favor to the American people? That's a question that's before us. I yield back.
Gentleman yields back.
The gentleman yield.
We're out of time. I can go to Mr. Ivey, and I'm sure he'll yield you some time. Or I'm not sure, but I would bet.
Let me go first, and I'll
Well,
give you
just
time. If I get
15 seconds.
All right, go ahead.
All right, thank the gentleman. The previous two speakers are concerned about me taking President Trump's comments out of context. This is exactly what they plan on doing if they can get their hands on this audio file. They want to take President Biden's comments out of context. So this is projecting. This is exactly what these Republicans are known for. They do it. That's what their big cheese does, Donald Trump. And with that, I'll yield back.
I thank the gentleman. I do wanna,
go ahead. I'll get time later.
Thank you, Mr. Chairman.
It's just not accurate. That's just not that's not our goal.
Well, I got to say, my colleague from Georgia raised the point about taking something out of context. There's certainly a concern about that, and I think it's a legitimate one. To not have the audio tape, but have the transcript, which again, nobody is actually alleged as incorrect in any way. It's not a verbatim transcript, that the person who took the transcript, violated her oath of office or his oath of office and taking the transcript. No allegations of that over there at all. So I think at this point, it's, you have to assume that it's factually accurate. But I had to get to this point, though, because I've got so many colleagues over there talking about the contrast, Biden wasn't prosecuted, but Trump was. But Hur sat right here. He issued a report that laid all of this out. But just to remind my colleagues, that Hur pointed out the distinctions between Trump's case and Biden's case and said, quote, they are clear. There are serious aggravating facts in the Trump case, most notably after being given chances to return classified documents and avoid prosecution, Mr. Trump allegedly did the opposite. According to the indictment, he not only refused to return the documents for many months, but he also obstructed justice by enlisting others to destroy evidence and then lie about it. And he goes on, in contrast, Mr. Biden turned in classified documents to the National Archives and the Department of Justice, consented to the search of multiple locations, including his homes, sat for a voluntary interview, and in other ways cooperated with the investigation. That's the distinction. And that's a distinction that the Department of Justice draws frequently in making decisions about whether to move forward with a criminal prosecution. And, you know, the obvious fact that you guys are ignoring when you talk, well, it's a Democrat versus a Republican, former Vice President Pence was not prosecuted as well for the same sorts of issues for the same reasons. There's a reason Trump sits alone or will sit alone at this criminal trial that's upcoming. It's because he acted to obstruct justice. Biden and Pence did not. And I got to say this too, just along those lines, because there's sort of this ongoing claim that the Department of Justice is somehow biased and only going after Republicans. But you know, a senator in New Jersey right now, a Democrat, who's about to start a jury trial. I don't know if they're still picking the jury or not, but they were last time that I looked. There's an indictment against a Democrat in Texas right now as well that just came down. It's a tough argument. It really flies in the face of all of these open cases or cases that are moving forward to suggest that for some reason the Department of Justice is only targeting Republicans when it's clear they aren't. And then the last point that you all keep kind of avoiding, Her sat here and testified. You guys are making allegations today that you did not confront him with at the time. To the extent you raised it, he said, no, I'm not trying to hide anything. I'm not trying to protect the president. We're not trying to slant anything. I did this. I called the balls and strikes as I saw them. And, you know, I think it's a bit of a smear to sort of suggest otherwise. And it's a little unfair to do it now when he's not here, when you had the chance to do it when he was here. And, you know, I don't know, it's kind of frustrating to me. The Judiciary Committee is supposed to be about upholding the rule of law. And I know there are political issues, it's a presidential year and all of that stuff, but you're deliberately distorting the facts over and over and over again. And it really should stop. It really should. And then just one final point on these issues. The Attorney General here, Merrick Garland, 92,000 pages that he's produced over and over, presented witnesses to the committee that other AGs would have refused to permit, especially, you know, lawyers who were in the middle of a criminal investigation or a pending trial. All of you all are ignoring that and trying to act like he's obstructing justice, even though you've got the verbatim transcript of the statement that he gave. With that, my time's expired and I yield back.
The gentleman yields back. I'll just respond briefly. Our motivation is exactly what I said 5 minutes ago. Is this the impartial administration of justice by the Justice Department? It's nothing else. That's our objective. That's our goal. And the best way to figure all that out is to get all the evidence. That's why we've asked for it. The gentleman from Maryland referenced when Special Counsel Hur was here. I did confront him. I laid out the same things. I know what to ask him. Did Joe Biden knowingly keep classified information? Yes. Did he knowingly release classified information? Yes. And why did he do it? Because he was writing a book. And how much did he get paid for the book? And he told me $8 million. So we laid all that out.
Will the gentleman
we laid all
yield?
that out
Will the
in that
gentleman
testimony. So I did confront him.
Will the gentleman yield?
Sure.
You confronted him with the facts those facts, but nobody said, you know what? You're not telling the truth. You're not charging him, and you should, because you're trying to protect him. None of you said that. Not one.
Of course I confront him with the facts. That's what you're supposed to do in these hearings. With that, I will yield the balance of my time to the gentleman from New Jersey.
Thank you, Chairman. Let me just say, I think you really encapsulated what this is about. You all are good at this. Seriously, and I mean that as a compliment. You're really good at it. You're good at politics. Because again, we're speaking about the rally in Wildwood, which I happen to be in. As you probably know, that's in my district. I spoke at it. And by the way, you're probably feeling a little bad about it because we had 100,000 people that were from all walks of life, from plumbers to pipe fitters to professionals to engineers and architects and doctors to young people to old people, all excited to be there. With 100,000 people, we had no incidents, nobody got drunk, nobody got hurt, there were no fights. It was a celebration of America. For an hour and a half, Donald Trump stood up there mostly extemporaneously speaking about a whole bunch of stuff, having a little bit of fun, sometimes being sarcastic, sometimes being very serious and speaking about America and America freedom and what's happening to our borders, our cities, what's happening to our country in so many different ways that isn't good. But my point is, that's not what this hearing is about. So once again, and the chairman encapsulated it, you're leading us astray. You're good at it. We're getting into a debate about Donald Trump. You're damn good at it. But that is not what this is about. This is about that we have existing transcripts, and we want to know what the demeanor of the current president was. We know what the demeanor of Donald Trump was because you can watch the whole hour and a half on tape. You can look and see what he said, what he did. You don't even need to do anything. I wish we didn't have to have this hearing either. I just wish they turned it over. The chairman wouldn't, I will in a minute, the chairman wouldn't have called this hearing if simply they had said, yes, you can have the video recordings, you can actually check out his demeanor. The problem you have, as good at it as you are, the problem that you have is either that he is cognitively impaired and doesn't know what's going on and what he's doing, or he's not, and he knowingly took all this classified material out and then basically sold it to a ghostwriter to make $8 million. And I know you're in a tight spot, but that's the reality. And so we kind of want to know what it is, and so do the American people want to know what it is. They just want to know the truth. This isn't a big deal. Tell the truth. It sets you free, man. So you can go through this inside out over and over, and I know probably the next speaker on your side is going to have another amendment that's got to do with Donald Trump, but that's not what this is about.
Will the gentleman yield?
Focused on the ball. I will yield.
I hadn't planned on bringing up Donald Trump today. You did it. You're the one that came in and said, and tried to, say that Trump was mistreated because he's on trial, but Biden is getting a pass. You brought it up. I just read back to you.
Reclaim my time. No, what I brought up was that you all were we were taking our eye off the ball. We still are. We're into this discussion. Yeah. There's a real serious issue here. And by the way, they obviously don't think, since you've brought it up, that Donald Trump's cognitively impaired because they're prosecuting him in different venues across the country, politically motivated. But I don't want to have that debate now, man. Mr. Ivey, I'd have that debate with you anywhere, anytime you want to do it. I will yield back in a minute.
It's my time. If the gentleman yield back, if the gentleman's done with yield back.
I will yield back.
Gentlemen, I would just point out the Jack Smith mishandled the evidence. We don't want to bring up Trump, but in that case, you got the prosecutor who sees the documents and changed the order that he sees the documents. The physical documents don't match up with the actual scanned documents. Some people might say that's tampering with evidence. That happened, and the judge down there said, wait a minute, we got to hold on here. What's going on? And of course, the irony is, Jack Smith mishandled documents while he's charging President Trump with mishandling documents. You can't make this stuff up. So I think in some ways, a reference to what's going on with President Trump is entirely appropriate. My time is up. Who seeks recognition? Question occurs then on the amendment from the gentleman from Georgia. All those in favor say aye. Those opposed, no. No. Opinion of the chair, the noes have it, and the amendment is not agreed to. Gentleman has asked for a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? No. Mr. Massey votes no. Mr. Roy? Mr. Bishop? Ms. Spartz? Ms. Spartz votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Armstrong? No. Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? No. Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? No. Ms. Hageman votes no. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Bush? Mr. Ivey?
Aye.
Mr. Ivey votes aye. Ms. Ballant? Mr. Gooden votes no.
Clerk will record.
Mr. Chairman, there are 5 ayes and 12 noes.
The motion is not adopted. Who seeks recognition? Ms. Dean from Pennsylvania.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report.
Amendment to
Gentleman
the
from Wisconsin is reserved a point of order.
amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find Merrick B. Garland in contempt of Congress for refusal to.
Without objection, the amendment is read. The gentlelady from Pennsylvania will explain her amendment.
I thank you, Mr. Chairman. I want to lay the table, and this builds on the amendment we just considered. The disinformation coming from the other side of the aisle is so troubling. It's funny, but it's really much more troubling than anything else. As we all know, Special Counsel Hur was not called in to do some sort of a competency hearing. He was to find out whether or not President Biden would be charged for mishandling of documents. I refer you to Mr. Hur, Special Counsel Hur's report here. We have every page of it. I forget how big it is here. Hold on. It's 350, 60 pages. Line 1, page 1. This is Special Counsel Hur's finding. And he said here to us, seated right at that table, that this was after, quote, rigorous, detailed, and thorough analysis by him and his group, his staff. Sentence 1, page 1. We conclude that no criminal charges are warranted in this matter. And then I thought very interestingly, and I even asked him to read this to us. The exception is former President Trump. I'm reading from page 11. Again, rigorously, thoroughly reported here by Special Counsel Hur in his conclusive findings. The exception, meaning that one person, one president, has been charged in misuse of classified documents. Page 11. It is not our role to assess the criminal charges pending against Mr. Trump, but several material distinctions between Mr. Trump's case and Mr. Biden's case are clear. You'll remember I asked Special Counsel Hur to read this. Unlike the evidence involving Mr. Biden, the allegations set forth in the indictment of Mr. Trump, if proven, would present serious aggravating facts, as my colleague read also. Most notably, continuing in the report, after being given multiple chances to return classified documents and avoid prosecution, Mr. Trump allegedly did the opposite. According to the indictment, he not only refused to return the documents for many months, but he also obstructed justice by enlisting others to destroy evidence and then lie about it. End quote. So let's talk about the elephant in the room. Why do my Republican colleagues need this audio file at all? After all, DOJ has provided 92,000 documents. It's plenty to go through, including the transcript, and let me hold that up, 2 days worth of testimony, the transcript of the president cooperating in the 2 days following the attack in Israel on October the 7th. But this president, this sitting president, cooperated fully and completely. Every word of his testimony is reported here. Do you think the Republicans really want to listen to the president's vocal tone, pace, inflections, verbal nuance, and other idiosyncrasies? I'll give them the benefit of the doubt. It may be they want to do that, but only because they think they can manipulate President Biden's voice to make it the next Trump for President ad. After all, they've done it before. Take a look. March 2020, Trump's White House social media director posted and Trump retweeted an edited video that cut off President Biden's sentence to make it sound like President Biden was endorsing Trump. Later that year, Steve Scalise shared an edited video of President Biden that falsely made it appear that he was supporting defund the police. And back in 2019, President Trump and Rudy Giuliani both retweeted a manipulated video of Speaker Pelosi that had been doctored to make the Speaker appear incompetent. Unfortunately, we know that our chairman, our very chairman, has taken part in these phony manipulations too. I have to admit to you, as a mother and a grandmother, this next example hurts the most. Last year, Ms. Nina Jankowicz testified in her deposition that Chairman Jordan actually tweeted a manipulated video of her that contributed to a deluge of death threats against her. She was 8 months pregnant, while strangers online called her a Nazi and told her she should die. She had to attend her
Will the
prenatal...
gentlelady shall suspend for a second?
I will not yield.
I'm not asking you to yield. We
What
are
is it?
citing a deposition. I have a point of order. There you go. The gentlelady,
I ask you to
yeah, it's 40 seconds.
restore the clock.
Yeah, I have a point of order. You are citing a deposition in your amendment that has not been released in violation of House rules.
Let me check with my team.
Yeah.
I'll make the point that they should release the deposition,
Yeah, we're happy to release the deposition.
and she should
All
be
right,
able
then
to
it's
quote it.
decided. They're happy to release the deposition. I ask for thank you for restoring my time.
We have to strike the language that is citing the deposition that has not been released by House rules.
Because you don't want to release it? You don't want to release what Mr. Jordan did?
I can't release it in real time.
I think you could. Ask the chairman.
Mr. Chairman, parliamentary inquiry. Can the chairman make a point of order? If so, who rules on whether...
Mr. Chairman, parliamentary inquiry.
Yes.
Can the chairman make a point of order? If so, then who rules whether the point of order is in order or not? No, the point of order is made by the chairman.
I can make a point, sua sponte, make a point of order. I'm in charge of ruling or enforcing the rules.
On your
of the
own
House.
point of order?
Yes.
Can someone else be heard on the point of order?
May I speak to the point of order? No?
Yes.
Mr. Chairman, the sitting chairman of this committee knows that this transcript was from last April. The committee has every ability and has awesome time to have released that. It seems to me and this side of the aisle that it is trying to be withheld in order to protect the chairman from something quite embarrassing. I ask that it be released today.
Would the gentlelady yield as
Hold on.
well?
I sure will.
Hold on.
Okay.
That requires consultation with majority and minority counsel, and the fact that you wish that it was released prior to that does not supersede the fact that a cited deposition that has not been released by this committee is cited in the amendment that is in violation of House rules.
Is the irony visible to anyone else here? Anybody else notice the irony here?
Mr. Chairman,
Objection.
Release the
Mr.
deposition.
Chairman, parliamentary inquiry.
You've got the whole transcript here, and you're afraid to...
Gentleman will state his inquiry.
What precisely in the amendment are you objecting to?
Just the content. The quotation.
Which quotations?
Page 2 and 3. We can just strike the quotes.
We're happy to release it tomorrow.
That's a decision for you all. The quotations in 2 and 3, page 2 and 3.
The quotation that reads, question, so it is fair to say the 1-minute video that Mr. Jordan linked to
Yes,
just made it
that's the
sound like,
quotation.
let me finish.
Right.
Just made
I
it
know what
sound like you
everybody
were
knows
endorsing.
about
Objection, Mr. Chairman.
Correct. I referred to
Objection.
it
Gentleman is out of order.
As a minute.
Objection.
Gentleman is out of order. Gentleman will suspend.
So Mr. Jordan relied on this kind of
Gentleman is
manipulation.
out of order. The gentleman will suspend.
Who is out of order?
You are, Mr. Napper.
Oh. I've made a parliamentary, why am I out of order? What am I violating?
You're disclosing the content of a deposition that has not been released by the House.
It's disclosed in this amendment that's already been published publicly.
Which is the entire point of the parliamentary inquiry.
Well, then I'm happy to amend my amendment to take out only the Q&A that you do not want revealed, because the chairman would be embarrassed by it. I will
Is there
take that out.
objection? You, yeah.
Wishful
Take it out
thinking.
of the record. Thank you.
On the point of order.
I want to be heard on the point of order. She's disclosed all this, she being Ms. Jankowicz, in interviews on multiple
That doesn't matter.
occasions.
I mean, her testimony towards that versus the transcript of the deposition are not the same. Disclosure
Well,
of the committee.
but the point there is, and I think the author of the amendment offered to strike the exact quotes, but the substance of the statements is public information.
Yeah. The amendment discloses committee record that has not been released in violation of House rules.
Well,
How about my amended amendment? I'm taking out the testimony which this committee, the majority on the committee, does not want revealed. And I guess I don't even want to ask, can we get the audio of that?
I mean, if you look at the footnotes, Mr. Chairman.
Will the gentlelady ask for unanimous consent to amend the amendment?
I ask for unanimous consent to amend the amendment to take out the language that you don't want revealed. Take out the Q&A.
Is there an objection? Without objection, so ordered.
Mr. Chairman.
Gentlelady is recognized.
I thank you. I think I had 40 seconds, but I'll take 30. Again, the irony is just extraordinary in this committee. Misrepresentation, a finding of incompetence by the former president, when you know this special counsel found. We conclude no criminal charges are warranted in this matter. It is absurd that the chairman of this committee, who sits in offense to his own subpoena, hundreds and hundreds of days, is seeking the voice of the president, whose voice he knows very, very well. The testimony is rich and complete. I ask that my amendment be considered and be honored and passed, because otherwise we could see the use of this audio, excuse me, to be doctored, to be deep-faked, and to be Trump ads. I urge all my colleagues to support my amendment. Thanks so much.
Anybody else seek recognition? Gentleman from Virginia.
I'm hesitant to speak because
Can't hear you.
I'm hesitant to speak, Mr. Chairman, because I'm so stunned by the amendment proposed by the gentlelady to get around House rules to disclose documents that have not been released by this committee. Is that how we're going to play now? Is that how the other side is going to play? Because that violates not just House rules, but general rules of decorum, general rules of decency. I mean, this committee has been a respected body in this Congress and many previous Congresses for many years. And one of the things that it emphasizes is not just the rule of law, but the balancing of the branches of government. When the executive branch overreaches its authority and says, we don't have to hand over these tapes to the legislative branch of government, we should be united in saying, how dare you? We should be united in saying, we represent the people. We are entitled to these tapes. We ask for them, we should get them. And to not just say no, but to say, to hell with your request, and to hell with House rules, and to hell with decorum, we're gonna make a mess of the rules that have been followed by this committee and many others for years and years is just offensive. So I oppose this. I'm going to reluctantly, well, the gentlelady's amendment is I'm going to oppose the amendment, but the way in which she went about her amendment, I'm going to strenuously oppose. I yield back.
Ranking members recognized.
I thank the gentleman. I want to point out two things. One, the striking hypocrisy of the majority in opposing this amendment, which simply reveals some records, while demanding the release of an audio tape of information that's already been released by transcript. And we know that in the past, the chairman of this committee has doctored audio tapes to make them say what they didn't in fact say. This amendment points this out. And I would also point out that even if the quotes are taken out of this amendment, which has happened, and whether or not this amendment passes, which it should, but in any event, this is all now on the public record, so you can't accomplish anything because it's out there. The hypocrisy, the dishonesty of the chairman is out there, revealed in the text of this amendment, whether it passes or not. And with that, I'll yield to Mr. Ivey.
Thank you, Mr. Ranking Member. I just want to point out a couple of things. One is, with respect to the specifics here, in the footnotes, it's clearly public information. Footnote 5 is Jim Jordan's Twitter account. So it's not like we made this public. That was already made public by the chairman. Footnote number 2 is the letter from the Department of Justice. Footnote number 3 is an article from the Associated Press. So let's not get over the top here and start complaining about, deeply secret or confidential information that's out there. But I do want to say this too, and to my colleague from Virginia, there's 115 plus transcripts from interviews that this committee's done that this committee's refused to disclose and make public. So we should do that. I mean, I hear all the statements today about, the public's right to know and we need the information. Let's do it. Put the information out, put out the 115, and then with respect to my colleague, and I'll say this too, because this goes specifically to the conversation we had at our last hearing, where I requested email communications between House Republican majority and the departments and agencies that we keep dragging in to produce documents. I moved to request the information. That wasn't agreed to at the time. So, this is not my time to yield, but, look, if you want to get upset about her making a statement, my colleague from Pennsylvania, where it's public information, I think that's incorrect. And to say you're offended by it, I think is kind of over the line. But if we want to turn the page as a committee, and you all want to disclose this information and make it public, by all means, let's do it. And I yield back to the gentleman from New York.
I'll yield back.
Anybody seek recognition? Gentleman from Georgia.
Thank you, Mr. Chairman. I yield to the gentlelady from Pennsylvania, Ms. Dean.
Thank you. I very much appreciate it. I wanted to tell the rest of the story that is public knowledge about what happened as a result of these misleading narratives. Ms. Jankowicz, after these misleading narratives were spread about her, she received tens of thousands of death threats. You talk about decency and decorum, a manipulated video. You talk about decency and decorum here, my goodness. She had to go to court to obtain restraining order against the individual who had harassed her and repeatedly doxed her family. She was 8 months pregnant while strangers online called her a Nazi and told her that she should die. And she had to attend her prenatal appointments in disguise to avoid being recognized and harassed on the street. When a reporter reached out to Chairman well, I'll skip that part. Ms. Jankowicz encountered a staffer responding that Ms. Jankowicz was on the board's public face and should thus be held accountable in public. As you see, I'm taking out Mr. Jordan's role in any of this because he doesn't want anything to be known about his role in this, and I really want to honor that. In August of 2020, the current House Majority Leader shared an edited video that changed the words of a disabled activist and spliced clips together to falsely portray President Biden appearing to support defunding all the police, even though Biden has specifically said that the reforms being discussed were not the same as getting rid of or defunding the police. I want to just say that it is strange to hear from the other side of the aisle that they're worried about decency or indecency. They're worried about decorum. Please take a look in the mirror at your own members, what they do to spread disinformation and lies, to confuse the public knowingly. To say that this somehow, Special Counsel's report was about competency is so shameful. You know that's not what it is about. You just don't like the results of the report. The results of the report being, we conclude that no criminal charges are warranted in this matter against President Biden. You don't like that. You wish you could have had it another way because your own candidate is rightly facing charges. With that, I do have one unanimous consent. I asked to enter into the record just so that we can be more complete because the majority doesn't want to reveal the transcript of their conversation with Ms. Jankowicz. This is public reporting. The article is A Surreal Experience. Former Biden Disinfo Chief Details Harassment. It is from March 8th of last year, and it is Politico.
Without objection.
Thanks so much.
Thank you. And members of this committee on the other side continue to repeat the falsehood that this hearing and this resolution is a part of an impeachment inquiry. Well, the last I heard about an impeachment inquiry by this do-nothing Congress after having spent $20 million in this committee investigating President Biden. The last I heard of an impeachment was by the chair of the other committee, the Oversight Committee, which has actually been the committee handling impeachment. And at that point, after they had President Biden's son in, Hunter, to testify and couldn't get anything out of him, the chair pretty much threw the towel in on, he threw in a white towel into the ring. And it was, gave up pretty much on impeachment. And now this committee is trying to drag it out of the garbage can and try to trick the American people into believing that this is a part of an impeachment inquiry. It is not. It's simply a expedition to try to make President Biden look bad in keeping with the report of Special Counsel Hur, who cleared President Biden, but nevertheless inserted some unnecessary and derogatory information in there that this committee has seized upon and continues to kick like a dead horse. And with that, I'll yield back.
Gentlemen, asked back who seeks recognition. Question is on the amendment. Clerk, all those in favor? Aye. All those opposed? No. In the opinion of the chair, the noes have it. Roll call. Roll call has been ordered. Clerk will call the roll.
Mr. Jordan. Mr. Issa. Mr. Gates. Mr. Biggs. Mr. McClintock. Mr. Tiffany. Mr. Massey. Mr. Roy. Mr. Bishop. Ms. Spartz. Ms. Spartz votes no. Mr. Fitzgerald. Mr. Benz. Mr. Benz votes no. Mr. Klein. Mr. Klein votes no. Mr. Armstrong.
No.
Mr. Armstrong votes no. Mr. Gooden. Mr. Van Drew. Mr. Nels. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye.
How's Mr. Issa recorded?
Mr. Issa, you're not recorded. Mr. Issa votes no.
Mr. Tiffany?
Mr. Fitzgerald, you're not recorded. Mr. Fitzgerald votes no.
How's Mr. Tiffany recorded?
Mr. Tiffany is not recorded. Mr. Tiffany votes no.
How's Mr. Roy recorded?
Mr. Roy is not recorded. Mr. Roy votes no.
Mr. Gooden?
Mr. Gooden votes no.
Have all members voted? Clerk will record.
Mr. Chairman, there are 5 ayes and 12 noes.
The amendment is not adopted. Who seeks recognition? Gentleman from Georgia.
Mr. Chairman, I've got an amendment at the desk.
Clerk will report. Reserved. Gentleman from Wisconsin's reserved a point of order.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find.
Without objection, the amendment's considered as read, and the gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. MAGA Republicans have spent $20 million this Congress investigating conspiracy theories and have nothing, absolutely nothing, to show for it. To date, MAGA Republicans have used this $20 million in taxpayers' money to hold 10 hearings before the Select Subcommittee on the Weaponization of the Federal Government, 6 of which have been on the same topic. They have conducted 121 transcribed interviews or depositions with witnesses from over 24 different companies, nonprofits, or federal government agencies. They've spent 555 hours of staff and witness time in these transcribed interviews and depositions. They've sent more than 60 subpoenas to executive branch agencies and private entities, and they've solicited over 3 million pages of documents from executive branch agencies and private entities. And despite MAGA Republicans' reckless and irresponsible spending of American taxpayer dollars on their witch hunt quest to find incriminating information on President Biden and his administration, they've been repeatedly excoriated in right-wing media for not accomplishing anything this Congress. In fact, as recently as April 28, 2024, Fox News host Maria Bartiromo stated, quote, "I mean, look, with all due respect, people are sick and tired of congressional investigations that go nowhere. People are sick and tired of letters being written and sent to the people who we know are bad in the first place," end quote. This is from their own gallery of supporters. To date, there is no evidence of any impeachable offense committed by President Joe Biden. There's no evidence of misconduct in President Joe Biden's administration. MAGA Republicans' witch hunt will go down in history as a total and complete failure, especially when viewed in light of the fact that we're reduced now to seeking verification of an erroneous report about President Biden's mental acuity. While I do not support the underlying report, I think that if the committee refers it to the full House, it should at least be accurate. A key Part of that accuracy is including the details of this protracted and over-the-top investigation in the background on the investigation section of the report recommending contempt. And for that reason, I urge you to support this amendment, and with that, I'll yield back.
Gentleman yields back. Gentleman withdraws a point of order. Question occurs on the amendment offered by the gentleman from Georgia. All those in favor say aye. All those opposed say no. No. Opinion of the chair is the noes have it. The gentleman has asked, has requested a record vote. The clerk call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Spartz? Ms. Spartz votes no. Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Shiapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Bush? Mr. Ivey?
Aye.
Mr. Ivey votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Roy? Mr. Roy votes no.
Clerk will report.
Mr. Chairman, there are 5 ayes and 12 noes.
The amendment is not adopted. Who seeks recognition? Gentlelady from Pennsylvania is recognized. We'll let her go.
Mr. Chairman, I have an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from Virginia.
Amendment to the amendment in the nature.
Objection, the amendment be considered as read. The gentlelady from Pennsylvania.
I object.
Okay,
It's brief.
Clerk will report, no problem.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find Merrick v. Garland in contempt of Congress for refusal to comply with the subpoena duly issued by the Committee on the Judiciary offered by Ms. Dean of Pennsylvania. On page 3, after the paragraph ending, quote, when his son Beau died, unquote, insert, however, it is in fact false that President Biden could not remember when his son died. In the transcript of President Biden's interview with Robert Hur, President Biden clearly recalls the date of his son's death, saying, quote, what month did Beau die? Oh God, May 30th, unquote.
Gentlelady is recognized.
I thank you, Mr. Chairman. My amendment corrects the record regarding the President's recollection of his own son, Beau Biden's death. And I saw in this markup today a welling up of decorum and decency and doing what is right. Just moments ago, you missed it, Mr. Chairman. And so I would think this will be an amendment that all of us can agree upon. It's an amendment about decency and facts and getting the record straight. As I pointed out when Mr. Hur was before us, President Biden clearly recalled the month and day his son passed. As on page 82 of the transcript, the complete transcript of his 5-hour deposition, he says, what month did Beau die? Oh God, May 30th, end quote. I find Mr. Hur's mischaracterization of that exchange in a government report to be inaccurate, grotesque, and gratuitous. That was nothing to do with the task he was given. it was just a free shot at a father grieving the grievous death of his son. Even more distasteful are Republican attempts to repeat that mischaracterization for political ends. Everybody in this room, everybody in this House must do better. But I suppose, you know what? Indecency is too often the point here. Finally, I'll note that in addition to his gratuitous and misleading statements concerning Mr. Beau Biden's death, Mr. Hur also determined on behalf of DOJ that President Biden would not be prosecuted for improperly storing sensitive documents, because in truth, the same cannot be said for Donald Trump. That's all the unrest on the other side. Mr. Trump remains the only former commander-in-chief to be criminally charged with endangering the service members he once led by leaving classified documents strewn around ballrooms and bathrooms and then hoping others would destroy or remove them. My amendment corrects the record on the important point of the president's searing memory of his own son's death, and I urge all members, those of decorum and decency, to support this factual correction. I yield back.
Gentlelady yields back. Gentleman from Virginia is recognized.
Mr. Chairman, speaking of the amendment,
Gentleman's recognized.
Mr. Chairman, I want to thank the gentlelady for making my point with her amendment. Not only did the transcript continue on after her amendment says May 30th, it continues, and I'll quote the transcript, with the question, was it 2015 when he died? I also thank the gentlelady for making the point that without the audio, we can't tell how much time passed between the question, what month did Beau die? And the words, oh God, the words May 30th, and how it was intoned, because he followed that with a question. Was, oh God, May 30th intoned as a question? We don't know because we don't have the recording. It's exactly why we need it. It's exactly why we've requested it over and over again, subpoenaed it, and now holding the Attorney General in contempt because he's not providing it, because we can't do our jobs for the American people accurately unless we have the most accurate information. And that's why we need the tapes, and that's why we're pursuing them, and that's why we're holding the Attorney General in contempt. So I oppose the amendment, and I yield back.
Gentleman yields back. Gentleman from Maryland.
Thank you. That's an interesting explanation, but I gotta say, it's hard for me to figure out how the length of a pause between an answer and a question would have, you know, any kind of dispositive merit one way or the other. Let's just hypothetically say, okay, pause for 2 seconds, as opposed to 30 seconds. If it's 30 seconds, then it's an impeachable offense in some way. That somehow transforms this transcript into the basis for legislative action or some sort of impeachment, or even if you want to go there, because you guys have offered about 5 different versions of why you need this, none of which are based are included in the report that, at least the one that you passed out. But just say hypothetically, what does that prove? You know, the comments about the demeanor evidence, which I think are equally problematic, because again, nobody's asserting, and certainly Hur didn't assert that he thought Mr. Biden's answers were deceitful or disingenuous or anything like that. But, and you know, the issues that you all have raised as potentially the basis for impeachment of some kind have nothing to do with, you know, when his son died or not. So it's just hard to figure out where you're trying to go with this from a legitimate standpoint. Now, I'm not questioning anybody's integrity over there, but I mean, there is this sort of obvious alternative track where it would be, they want the audio tape so they can use it, maybe not them personally, but somehow it might end up in a video, maybe a campaign video, maybe an election video that supports President Trump's effort to be reelected in his race against President Biden. You know, I got to say, it sort of makes more sense than the explanations I've heard from the other side. And, you know, the legislative purpose issue, which I really haven't had much of a chance to touch on yet, but we can do it now. The Supreme Court said one of the bases of oversight in seeking this information is there's a legitimate legislative purpose for getting it. And I'm not seeing the legitimate purpose that isn't served by the transcript. Because if you have the transcript and you have and it's a verbatim transcript, and as I said earlier, nobody over there is asserting that somehow the court reporter doctored it, fabricated it, did anything wrong with it, anything like that. As far as I know, nobody's made an inquiry with respect to the court reporter to ask her, you know, if she did something, you know, inappropriate. And certainly Mr. Herr, who came in here and testified, and you could have asked him about that, he never said anything about a doctored transcript either. So I'm not seeing where you're going with
the
this.
gentleman yield?
I will.
Does the gentleman agree that the amendment is incomplete when it does not include the question that follows that statement of May 30th?
I mean, I don't think so, but I mean, she might be open to you offering an additional amendment to add language if you want. But the bottom line is, from the standpoint of at least having a fuller transcript, because there's no doubt that the way the report was written, at least the one that, I don't know what the final one's going to look like because we don't have it yet, but it was about as one-sided a document as you can get. And so from the standpoint, and I'll say this again, because this is going to be the basis, we went through this on the Hunter Biden version of this as well. This is going to be what we send to the court, and I hope the Department of Justice does take this to court, because I want to see it litigated. I want to see a judge rule on this, because I think the majority's way over the line and the way it's abusing the authority here. But I'm really not seeing the reasoning behind why it's so critical to have the audio tape in a way that's not, you know, not addressed by the actual transcript, which again, nobody has questioned its accuracy. Nobody has questioned, you know, that it was doctored or in any way. Well, actually, somebody did sort of throw out that assertion on the fly, but there's absolutely no factual basis for it. Nothing, certainly, that was sustained by Mr. Herr, who again was here, testified, and y'all could have asked him about it, but nobody did. So, not saying anything about bad faith here, but the only explanation for why you all are making such a big deal about this is that you want the audio tape, and it might turn up in campaign ads down the road in the race for president. And with that, I yield back.
Gentleman yields back. Question occurs on the amendment offered by the gentlelady from Pennsylvania. Those in favor say aye. Aye. Those opposed, no. No. In opinion of the chair, the noes have it. The gentlelady requests a recorded vote. The clerk call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Bishop? Ms. Sparts? Ms. Sparts votes no. Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye.
How am I recorded?
Mr. Issa, you're not recorded. Mr. Issa votes no.
Gentleman from Texas.
Mr. Gooden votes no.
Clerk will report.
Mr. Chairman, there are 5 ayes and 12 noes.
The amendment is not adopted. Gentleman from Maryland is recognized.
I have an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from North Dakota.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find Merrick B. Garland in contempt of Congress.
Without objection, the amendment is considered as read. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. I offer this amendment just to walk through it briefly. This goes to the issue of the distinctions between the case against Mr. Biden and the case against Mr. Trump. There have been multiple allegations today about, from the Republican side, that somehow the Department of Justice gave favorable treatment to President Biden. But I wanted to offer this amendment to make sure the record is clear, and also to make sure not just that the record of the discussion today is clear, but also that the report that ends up being sent forward, and I think is going to be the lead document if this gets to court, and again, I hope it does. But I think it balances out the one-sidedness, or helps to start and move it in that direction of the report that the committee has floated, the Republicans have floated. There are, on this point, Special Counsel Herr, who testified here and said this in the report as well. Several material distinctions between Mr. Trump's case and Mr. Biden's are clear. There are serious aggravating facts in the Trump case, most notably after being given multiple chances to return classified documents to avoid prosecution. Mr. Trump allegedly did the opposite. According to the indictment, he not only refused to return the documents for many months, but he also obstructed justice by enlisting others to destroy evidence and then lie about it. In contrast, Mr. Biden turned in classified documents to the National Archives and the Department of Justice, consented to the search of multiple locations, including his homes, sat for a voluntary interview, and in other ways cooperated with this investigation. And the final point here, I think, is that unlike the deliberative acts of former President Trump to retain and conceal classified materials from the federal government, Special Counsel Herr found likely inadvertence and or mistake. And so we go on to quote some of the language from his report as well. We find the evidence as a whole insufficient to meet the government's burden of proving that Mr. Biden willfully retained the Afghanistan documents in the Virginia home in 2017. For other recovered classified documents, the decision to decline criminal charges was straightforward. The evidence suggests that Mr. Biden did not willfully retain these documents and that they could plausibly have been brought to these locations by mistake. Unlike President Biden, Donald Trump intentionally and flagrantly took and concealed highly classified documents. Mr. Trump's actions are extremely serious and warranted the 32 counts of willful retention of the documents as he was charged. I want to say this as well, and I think I mentioned this earlier. Former Vice President Pence faced a similar factual scenario. There were documents found in, I believe, in one of his residences. Unlike Mr. Trump, Mr. Pence turned them over. He cooperated immediately. There was no evidence of any type of an effort to try and obstruct the investigation, hide the documents, or anything like that. Certainly didn't ask anybody to move the documents for him, as Mr. Trump, I think this was raised in the indictment, had done. So I ask that this be included for the point of completeness. We want to make sure we send a document I would oppose the whole thing, as I've stated repeatedly today, but if you're going to forward this document, at least send a document that has some semblance of balance to it, and I think shows the effort to try and present the court with a full take on information with respect to this particular issue. And as I mentioned earlier, this wasn't a place I was expecting to need to go today. I thought we were going to be focusing more on the specifics of, especially the executive privilege issue after it was asserted by the White House. There's been almost no discussion on the legal merits of that from the Republican side. And I guess with good reason. They don't seem to have a strong argument to address it. But since you brought this up, since you brought up the Trump contrast with Mr. Biden and sort of coupled it not only with allegations of misconduct by the overall Department of Justice, but specifically Mr. Hur, who I don't necessarily agree with everything he wrote, but I certainly am not going to sit here and essentially slander him for, trying to be unfair, tilting the system, trying to cover up for the president. None of that is merited, and I don't think there was anything about the report or his testimony that he presented here that would support that. So, and with that, I yield back.
Gentleman yields back. Gentleman from North Dakota is recognized.
Strike the last word in opposition to the amendment, but it almost passively aggressively proves the point. This wasn't substantially similar to Vice President Pence. It wasn't substantially similar to Donald Trump. We have a 40-year history of keeping classified documents, 40 years. It's why the audio is important. He's reading classified documents to his ghostwriter, reading them to him. Like the dismissal, this isn't, I've worked with the DOJ in an adversarial way, and you know what I've never seen for a regular defendant in criminal court? The DOJ making the plausibility defense over a 40-year history. And we talk about disingenuous and all of those things. If you spent 40 years robbing liquor stores, and then you cooperated with law enforcement, they're not going to charge you. That is a sentencing factor. That's an obstruction factor. That is a different factor. If you're going to the underlying offense of maintaining and disclosing classified documents, that is a significantly different thing. And only in this world would you go to that place where we'll say, hey, you committed the underlying crime, and you did it for 40 years. But you cooperated with us, so we're going to allow you to skate. That's the difference. You spend a lot of time talking about the obstruction charge, but we don't spend enough time talking about the egregious nature of the underlying maintaining and disclosing classified documents. Like, that's the difference, and that's the problem. And that's why audio matters, because the audio matters, and there's inflection, and there's different ways in which you do it. I mean, if you're telling your ghostwriter in a laughing matter that you are reading classified documents to him as he's writing your book, that's different than a lot of different ways in which you do it, and the transcript is all of that. But there is no other scenario, and by the way, I would have gotten into this with Special Counsel Prosecutor Hur, but we have the 5-minute rule, and I had a lot of other things to get out. But you can talk about the secondary part of this case all day long, but I don't think anybody who reads the report, looks at the nature, he did it when he was a senator, he did it over 45 years, he had been warned about it and continued to do it. You have to seriously jump through some hoops to get to the inadvertent part of it. And so you're talking about maintaining and disclosing classified documents. And if anybody thinks that the information in the Hur report doesn't give a valid reason for that occurred knowingly and willingly, then the question is, why wasn't it knowingly and willingly? And that's where we're at this point. So
Would the gentleman
talk about
yield?
obstruction. I'm going to yield to the gentleman, Mr. Bentz.
Thank you. Just a question. If I recall correctly, when I asked Mr. Hur if his report exonerated the president, his answer was unequivocally no. Is this consistent with your thought?
Well, and absolutely, and we've heard that over the course of this whole thing. There is no claim of innocence. There is no finding of innocence. That is not how reports work. But we keep going past the underlying offense, which is the classified documents offense. And why wouldn't you cooperate? Like, why wouldn't you cooperate when you have the ability and knowing exactly how everything works through and where the differences lie? Yes.
Yes. So thank you for the yield. It just seems to me that Mr. Hur was saying we don't exonerate. What we're going to do is say that that the president is an older gentleman who is incompetent, and we don't think we can get a conviction, therefore we're not going to prosecute. But to that point, I want to ask you as a federal prosecutor.
Oh, no, as a defense attorney.
The best evidence rule. You can talk about that just for a moment, because I know it goes both ways lots of times, but is there any doubt in the world that the best evidence of what we're trying to get at here is the verbal recording?
There's a reason for the last 5 years in Congress, I have worked with my friends on both sides of the aisle to get to custodial interrogations being recorded by federal law enforcement. Take it completely out of this room and this political thing. And to be honest, oftentimes I fight with my side of the aisle on that issue more than I fight with your side of the aisle. The reason you want audio, the reason you want video, the reason you want those things is because it is without a doubt the best evidence that exists in which to overall deal with the issues that you're trying to incorporate. And if you want to talk about legislative purpose, as somebody who has been watching this happen from the minority and the majority for 5 years, there is the equal application of justice part of this answer. We have a guy that was prosecuted a year after he altered an affidavit in front of a court, and he's currently practicing law in Washington, D.C. right now. And so with that, I see my time has expired, and I yield back.
Gentleman yields back. The young lady from Vermont's recognized.
Thank you, Mr. Chair. I yield my time to the gentleman from Maryland, Mr. Ivey.
Thank you. I just want to run through some of the statements that were just made a moment ago. I guess I can work my way backwards to some extent. With respect to the recording of statements, and I share the gentleman's view about the importance of the federal investigators recording statements, but I would make a couple of notes to that. The first is, for example, there are no videotapes of grand jury testimony, for example. They're all electronically transcribed by court reporters in the room. And nobody would argue, that I'm aware of, that that's not evidence sufficient for use in court, for use to charge for criminal purposes, for example, for false statements or perjury.
Would the gentleman
or impeachment. I will.
Yeah, I don't disagree with that, because in that scenario, it's the best evidence.
Yeah, it's certainly sufficient for the basis for criminal charges. And with respect to scenarios where you have a transcript and a videotape, if the videotape, you can use the tape or the transcript for impeachment purposes or whatever. I mean, it's sufficient. So the point here, I think, though, given the nature of the proceeding, it's incumbent on you all to show that there's some additional evidence that you can get from a videotape that you can't get from the transcript. Yeah, you may have given me the funny look, but that's what's going to be required. If this goes to court, we would have to justify a finding of contempt, because the burden would be on this committee to show contempt, right? So what's the difference between the transcript and the tape? And you've talked about the lapses in time, and I just questioned a moment ago. I don't know how that gets you from, it's a 5-second pause, it's a 15-second pause. I don't know how that gets you from a statement to that's therefore impeachable or chargeable or anything along those lines, which is what's required. In the legislative purpose standard, I haven't heard a reason for how it's not satisfied by the verbatim transcript, which you've already been presented with. And there's no question about it being verbatim and accurate based on what Mr. Herr said and based on the certification that this received at the time that it was recorded and printed. You mind if I yield to the gentleman from California?
I don't.
I yield to the gentleman from California.
Thank you, Mr. Ivey. And I think the point is, it's never going to be enough. Like, you guys are not doing oversight, you're doing overkill. And as soon as you get the audio, you're going to say, well, we wish there should have been a video. And then you'll get a video. And then you'll say, well, we wanted his health records. Like, well, who knows, like, if he, wasn't on some medication that affected it. And then once you get that, you're going to say, well, there was not a polygrapher there. We don't know if he was telling the truth or not. You have been thoroughly, and I want to emphasize, thoroughly humiliated in your impeachment quest, which, by the way, is that happening? Is that dead? I pronounced it dead a couple weeks ago. Is it happening? I don't think it's happening. And so you're humiliated. And so you're digging and digging and digging and digging, and you just want more. But guys, It's not happening. You're not impeaching him. You have nothing. I just invite you to move on. Like, let's do something that actually helps people. Just move on. And we're never going to make you happy because you just don't accept him as president. And so we're wasting everyone's time by doing this exercise. And I yield back.
Would you yield for a minute?
I yield to Mr. Cohen.
Thank you. Mr. Abbey, I very much like Governor Armstrong, and I'm happy to work with him. Well, he's still been here, but he won't be here soon. But this whole thing was about whether or not the president, when he was the vice president, violated the law. Mr. Hur said he definitely took these documents. There was no question about that. But he couldn't get a conviction because he was a sympathetic character. So what good is it going to do if they get to hear him say he was a sympathetic character and why they thought that? That's not the issue. The issue is, did he take the stuff or not? Hur said he took it. There's no question about it. He took the stuff, and for his biographer. And Jordan says motive and blah, 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 and indictment. It's about the fact he's a sympathetic character and you couldn't get a conviction. That's the issue. So we're off on rabbit trails. You should never get off on rabbit trails.
And just to sort of make a final statement here, the amendment I'm offering doesn't actually go to that. It just goes to the fact, the distinctions that Herb drew between Biden and Trump with respect to the mishandling of documents and the obstruction of justice that occurred afterwards. So I would hope that we can get a vote on the merits from my colleagues on the Republican side on that amendment.
Gentleman yields back, or gentlelady yields back. The question occurs on the amendment offered by the gentleman from Maryland. Those in favor say aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it.
Ask for a recorded vote.
The gentleman has asked for a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Bishop? Ms. Sparks? Mr. Fitzgerald? Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Dean votes aye. Ms. Escobar? Ms. Ross? Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Aye. Ms. Ballant votes aye.
Chairman, am I recorded?
Ranking member.
Mr. Nadler, you're not recorded.
Aye.
Mr. Nadler votes aye.
Gentleman from Virginia.
Mr. Klein votes no.
Gentleman from Texas.
Mr. Gooden votes no.
Gentleman from Kentucky.
Mr. Massey votes no.
Clerk will report.
Mr. Chairman, there are 8 ayes and 9 noes.
The amendment is not agreed on. Who seeks recognition?
Mr. Chairman, I have an amendment at the desk.
Gentleman from California. Clerk will report. Point of order reserved by the gentleman.
Amendment to the amendment in the nature
Without
of a
objection, the amendment will
substitute.
be considered as read.
I object, Mr. Chairman.
The clerk will report.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find Merrick B. Garland in contempt of Congress for refusal to comply with the subpoena duly issued by the Committee on the Judiciary, offered by Mr. Swallow of California on page 6 at the end of the paragraph that begins, quote, to further the committee's constitutionally mandated oversight and legislative duties, end quote, insert a new sentence which reads, quote, however, taking into account that multiple members of this committee, including the chairman, remain out of compliance with subpoenas issued to them by another committee of the House of Representatives, no member of Congress will be permitted to vote to hold any other person in contempt of Congress until such time as they provide the testimony that has been required of them regarding their participation in the planning and execution of the events that took place on the United States Capitol on January 6, 2021, end quote.
Mr. Chairman, this amendment plainly says that if you have not responded to your own subpoena, you can't bring a subpoena or seek compliance upon anyone else. In the law, we call it the unclean hands doctrine or the clean hands doctrine. It's a legal principle in common law that prevents a party from receiving relief from a court if they have acted unethically or unjustly in relation to the matter at hand. At our own home, it's called the wash your hands before dinner doctrine. And my 6-year-old and 5-year-old and 2-year-old, they're not coming to the dinner table until they themselves have clean hands. There are dirty hands on the other side. Multiple times, 2 members of this committee have been asked to comply with a subpoena related to January 6th. One of those members, I don't think is here today. I think he's up watching Mr. Trump's trial. But most simply, don't come at us about anyone else's compliance if you are out of compliance. And the chairman is 735 days, 17 hours, 19 minutes, and 24 seconds out of compliance of his own subpoena. And so this amendment would prohibit the chairman or anyone else from bringing compliance or contempt upon somebody for another matter. And I yield back.
Gentleman yields back. Point of order being withdrawn. Gentleman from Virginia.
Speaking of the amendment.
Gentleman is recognized.
I thank the chairman and I thank the gentleman for his remarks. I've heard them a couple times. And in responding, I would just say that, first of all, the subpoenas for the members of this committee are no longer in effect because the last Congress has finished. We'll just make that point first. But we also want to look at the responses that were made by the chairman to the January 6th committee. The chairman never declined to testify. The chairman, in fact, wrote every time he was asked to testify and responded with further requests for either statements or further requests for responses from the committee, and never received any responses from the committee. Never expressed an unwillingness to testify. So the characterization that he refused is inaccurate. And it's clear that Democrats were subpoenaing Republicans for political reasons at the time. Chairman Thompson stated that he pursued these subpoenas in part to, quote, weaken Republicans if they took the majority in the future. And so we see through the political motivations of those who issued the subpoenas to begin with and those who want to make it a political point now. So I oppose the amendment and I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Maryland.
Thank you, Mr. Chairman. To my colleague from Virginia, yes, we've had this discussion before, but just a couple quick things to clarify the points you just made. The first was, yes, there was an exchange of correspondence between the chairman and the committee. The problem was the chairman made, in my view, demands that were unusual, to say the least, in response to a subpoena, like, tell me how you're going to use the information and give me the information that you have about that's related to my testimony in advance of me coming. In other words, he wanted discovery before he showed up to give the statement. Now, let's compare that to what we've got before us with respect to the Department of Justice. And in this particular instance, not only has there been substantial compliance with respect to, I wish I had it in front of me, the number of subpoenas and document requests, and I remember it's 92,000 pages of documents. I think it's like 40 witnesses from the Department of Justice, and as I mentioned earlier, some of those witnesses were prosecutors in, mid-investigation who the department still produced for statements and transcripts here before the committee, which I think is totally inappropriate and actually potentially interferes with the legitimate prosecution efforts by the Department of Justice, ironically in one instance with respect to Hunter Biden. So, let's be clear about that piece. And then as I mentioned earlier today, if we're going to stay on the substantial compliance standpoint, just in this particular request, there was a report generated by Mr. Herr that the department was not required to turn over, but Mr. Garland decided to turn it over anyway on his own initiative. With respect to the transcript, again, there's no statutory requirement that he turned that over, but he did turn it over. And he made Mr. Herr available to testify. And Mr. Herr, he resigned right before he gave the testimony, which was fine, but it's clear that the department was not trying to block him providing testimony to this committee. So from the standpoint of substantial compliance, this is an outstanding record for the Department of Justice. Now, I won't go into the contrasting point that Mr. Swalwell made. I think he laid it out pretty good. But let's be clear about this. The compliance we've had here, I think, has been really extraordinary. The executive privilege claim, which was raised by the department, again, really has not been addressed, certainly not on the legal merits by the Republicans in this committee. And as I mentioned earlier today, I have a letter that was dated May 1, 2019 from the Barr Justice Department to Mr. Nadler, who was the chairman at the time, raising basically most of the same points that we're talking about today. Now, with respect to the chilling effect issue, which you all sort of poo-pooed a few minutes ago, similar access by the department could be impeded in future investigations if the White House were given reasons to believe that Congress would receive each and every document shared with the department. Now, this is Barr's department objecting to turning over documents where there was no predicate provided already. In this instance, you've got the transcripts, you just want additional information. As Mr. Swalwell said, apparently, you'll never get enough. And then the Barr Department of Justice said, the committee has not articulated any legitimate legislative purpose for its request for all of the special counsel's investigative files. This is for the Mueller report. The committee has no legitimate role in demanding law enforcement materials with the aim of simply duplicating a criminal inquiry. Now here, the Merrick Garland Justice Department gave you the transcript, gave you the report, gave you the lawyers to testify about what they'd done. Barr objected to all of it with respect to the Mueller report, raised the same sorts of issues. Now, those have been addressed in a different forum. But here, you guys are ignoring the compliance that's been provided by the Department of Justice over and over and over again. I'm running out of time, but my point here is that you've got substantial compliance from the Department of Justice. Mr. Chairman, the record is what it is. I think we've discussed it before on multiple occasions, and Mr. Swalwell's raised it as well, but I think it's a contrast that bears noting in this particular instance, especially where we're seeking contempt against the Attorney General of the United States. And with that, I yield back.
Gentleman yields back. Gentleman from Virginia for unanimous consent.
Ask unanimous consent to insert into the record 3 letters from you to Chairman Thompson, dated January 9th, 2022, May 25th, 2022, and June 9th, 2022.
Without objection. Who seeks recognition? Question occurs on the amendment offered by the gentleman from California. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the noes have it. and the amendment is not agreed to.
Recorded vote, please.
The gentleman asked for a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Gates?
Thanks, Ben.
Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Bishop? Ms. Sparts? Mr. Fitzgerald? Mr. Bentz? Mr. Bentz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Massey? Mr. Massey votes no. Mr. Gooden votes no. Mr. Chairman, there are 9 ayes and 12 noes.
Who seeks recognition? Gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chair. I have an amendment at the desk.
Clerk will report.
Amendment to,
Gentleman from Wisconsin reserves a point of order.
amendment to the amendment in the nature of a
Without objection, the
substitute.
amendment be considered as read. Gentlelady from Pennsylvania is recognized to explain her amendment.
Thank you. If there were any question about whether today's hearing is a legitimate exercise of Congress's legislative or oversight powers, our colleagues across the aisle have effectively eliminated that possibility with their combined remarks today. They've spent hours trying to defend the indefensible conduct of the leader of their party, misstating the conclusions of the special counsel's report and smearing the President of the United States with politically inspired lies and innuendo. This markup is, in fact, nothing more than political theater by Donald Trump's allies in the House Republicans who've wasted more than a year of the people's time and 20 million taxpayer dollars on a blatant act of petty vengeance. Now, rather than admit that they've found nothing and been embarrassed every step of the way, they're shamelessly plowing ahead. Instead of cutting their losses, they're once again trying to drag the president, this chamber, this committee, the American people, and now the Attorney General down a rabbit hole of conspiracies and untruths. What we have here today is not a legitimate oversight or legislative effort. It is guided not by our Constitution, but by the former president's calls for retribution against his political rival and the cowardice or complicity of his supporters. And it's nothing but an attempt to distract from Mr. Trump's ongoing criminal trial and to prop up his reelection bid. In case it's not clear enough already, constitutional scholars are not driving the House Republicans' impeachment stunt. So my amendment adds important context about the actual purposes and parameters of impeachment to this exercise. In his report, Special Counsel Hur noted that laws about handling classified material do not apply to a sitting president or vice president. So even if Hur determined there were criminal conduct, which he did not, it could only have applied to the time before Joe Biden was elected. Even House Republicans' longtime favorite pet legal scholar, Jonathan Turley, testified before the Oversight Committee last year that impeachment proceedings for pre-office conduct unrelated to current actions is controversial and must be approached with abundant caution. As Turley acknowledged, Launching investigations on that basis would convert impeachment into a rationalization for subjecting officials to limitless inquiries. Contrary to that advice, there's been no abundant caution in this illegitimate process. Clearly, there's no real basis for Republicans' claim that they need these audio files besides political theater. And the Department of Justice has rightly pointed out that allowing the House majority to weaponize investigative materials in this way would pose a strong risk of jeopardizing the willingness of other witnesses to come forward in the future. Ultimately, as our colleagues have proved time and again, their impeachment stunt has no basis, no evidence, and no high crimes or misdemeanors to show for it. And today is just another desperate attempt to save face and suck up after their bogus investigation has failed to bear fruit. The American people can see this for what it is, and they deserve better. We should have enough of these ridiculous games and get back to working for the American people. I yield back.
Gentlelady yields back. Point of order is withdrawn. I'll recognize myself to speak against the amendment. Special Counsel Hur could have said that. He could have written the report and he could have said we don't prosecute sitting presidents. That's not what he said. It just simply isn't. The report went through in detail, and now we're asking for the best evidence of why that report was written that way. And with that, I yield back. Anybody seek recognition? The question occurs on the amendment offered by the gentlelady from Pennsylvania. All those in favor say aye.
Aye.
All those opposed, no. In the opinion of the chair, the noes have it.
I would request a recorded vote.
The clerk will call the roll.
Mr. Jordan? Mr. Issa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? No. Mr. Massey votes no. Mr. Roy? No. Mr. Roy votes no. Mr. Bishop? Ms. Spartz? Mr. Fitzgerald? No. Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Klein? No. Mr. Klein votes no. Mr. Armstrong?
No.
Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Schiff votes aye. Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Mr. Nickus? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Ross? Aye. Ms. Ross votes aye. Ms. Bush? Mr. Ivy?
Aye.
Mr. Ivy votes aye. Ms. Ballant?
Aye.
Ms. Ballant votes aye.
Mr. Van Drew?
Mr. Van Drew votes no.
Mr. Gooden?
Mr. Gooden votes no.
Mr. Bishop?
Mr. Bishop votes no.
Clerk will record.
Mr. Chairman, there are 9 ayes and 12 noes.
The amendment is not adopted. Who seeks recognition? I have an amendment at the desk. Clerk will report.
Amendment to the amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find Attorney General Merrick B. Garland in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on the Judiciary offered by Mr.
Without objection.
I reserve a point of order.
The amendment is considered as read. Gentlelady reserves a point of order. Chair now recognizes myself to explain the amendment. A mere 2 hours before this markup session was scheduled to start, the committee received letters from the White House and the Department of Justice informing us that President Biden is invoking executive privilege to prevent the department from producing the audio recording of his and his ghostwriter's interviews with special counsel Hur, among other materials. The committee has numerous concerns about the validity of the president's assertion. First, the president has already waived any potential assertion of executive privilege over the information discussed in his interviews with special counsel Hur when he leaked the transcripts of his and his ghostwriter's interviews with special counsel Hur to the press. This conclusion is consistent with the court's decision in U.S. v. Mitchell, which rejected a presidential claim of privilege over audio recordings where, as here, the president caused to be reduced to transcript form and published the information in the subpoenaed recordings. The Mitchell court concluded that the executive privilege claim was non-existent since the conversations are no longer confidential. Accordingly, when the president leaked his and his ghostwriter's transcripts, his ability to invoke executive privilege was no longer existent. The president and the department could have taken steps to protect the confidentiality of the transcripts, but failed to do so when they released them to the press prior to providing them to this committee. Second, the assertion of privilege is 3 months late and therefore not valid. To have been timely, any privilege should have been asserted by March 7th, 2024, the subpoena return date. Third, even if the president's invocation was valid, which it is not, it is certainly overcome by the committee's need for this information. The committee has demonstrated a sufficient need for the audio recordings as they are likely to contain evidence important to the committee's impeachment inquiry and legislative oversight. Additionally, the audio recordings sought by the committee cannot be obtained from any place other than the department. Without these audio recordings, the committee's important legislative work will continue to be stymied by this president and the Department of Justice. The audio recordings are necessary to evaluate what government reform is necessary within the department. This amends the Ains contempt resolution in light of the president's invalid assertion of the executive privilege. However, this assertion does not change the fact that the Attorney General is in contempt of Congress today for his failure to turn over all responsive material to the committee's subpoena.
I withdraw my point of order.
Gentlelady withdraws. Who seeks to be recognized? Gentleman from Maryland is recognized.
I have a question. What does the amendment do? Did it strike the language of executive privilege throughout the amendment, or what did it do? I'd ask that my time be stopped.
It updates the report to the department and the president's office of waiving executive privilege.
Okay, well, I guess what I'm specifically asking, though, is my recollection is I came across 7 instances where executive privilege was cited in the report. That was the amendment in the nature of a substitute this morning. What's been done with those?
It updates those assertions of privilege to account for the letter we received this morning.
It strikes it at least 6 times and then inserts what
So I see, let's see, 1, 2, 3.
I have it 6, and then the insertion of the new text
Okay.
about what happened this
All right. Let me do this with the time I've got left. I'll have to try and read through it quickly to see, but the waiver issue, I think, is, I just wanted to address that because the department specifically spoke to that, and it's May 16th letter to both committees. Finally, I note that the department's disclosure of the transcripts of the interviews does not constitute a waiver and does not preclude an assertion of privilege with respect to the audio recordings. As I have explained, audio recordings have distinct features and law enforcement uses which implicate privacy interests and risks of misuse to a greater degree than transcripts, and disclosure to Congress of the recordings would have a chilling effect on future cooperation in similar investigations. So I think it's pretty clear that the waiver issue has been addressed, and I think the assertion here and the amendment I haven't had a chance to read yet because I only got it 30 seconds ago. Actually, 2 minutes ago, 2.5 minutes ago. I apologize. But I think that's been directly challenged, and so I'm curious about how the report addresses that challenge that's raised in the letter that I guess this report is supposed to be responding to.
Well, a couple points. One, it's the leaking to the press in the Mitchell case. I mean, giving the transcript to the committee is one thing. They also leaked it to the press. And two, I mean, you can read through it, but we got the letter from DOJ this morning. So that's where we're at and why.
No, this letter is that I'm talking about here is from May 16.
Well, I'm saying the amendment is because of the letter we got from today. Today is May 16th.
I'm sorry. No, that's where is that? I'm sorry, this is yesterday, May 15, where they raised this point.
It was an enclosure yesterday. They didn't send us the letter yesterday until this morning.
Well, in any event, I haven't had a chance to look at the Mitchell case. I'm not familiar with the executive privilege being time barred in cases where it's been raised. In fact, I think just off the top of my head, some of them have been raised months, maybe even years after an initial request has been made, because frequently it takes a long time for these sorts of disputes to play out. So I do want to challenge the language in the report with respect to the changes for executive privilege. And the claims that they've made waiver of the privilege, which I don't believe is the case, and I think there's been no showing of need with respect to the contrast between the transcript and the tape, and that the courts, well, the committee's essentially set an artificial deadline here, which is not sufficient line to time bar the assertion of the executive privilege. And with that, I yield back.
Anybody else wish to be recognized?
Yes, sir.
Gentlewoman from Pennsylvania.
Move to strike the last word.
Gentlelady is recognized.
Thank you. I still don't see that the committee has, or that the majority has made out a sufficient legislative or oversight purpose. I mean, we seem to keep getting this word salad of it's important that we review the actual audio tape as opposed to the transcript because it's important, because we have important interests we're trying to address, so it's important. It's kind of a lot of word salad, kind of like saying that you need an appropriate rule, which would be one that's appropriate. So I would just object to the amendment on the grounds that the majority has not made out a clear legislative or oversight purpose, unless they're suggesting that there's been some kind of chicanery or something here in the Department of Education or Department of Justice or by the special counsel. So I would just say that I don't think that there's been the basic premise has not been met by the majority, and I would yield to Mr. Ivey.
I thank the gentlelady. I'm just taking a quick look at Mitchell here now, and this was a subpoena to John Mitchell, who was then the Attorney General, from the special counsel. And I haven't had a full chance to read this, but in the Watergate litigation, one of the points that was made by the courts repeatedly was that intra-branch disputes were treated differently than disputes between the executive branch and the legislative branch. And it looks like here, this is also another one of the mid-trial requests for the information, which has an exigency requirement or impact that's not present in the scenario here today. So I would urge the majority to reconsider reliance on this particular case because I think it's inapplicable for those reasons. And with that, I yield back to the gentlelady from Pennsylvania.
And I would yield back.
Gentleman from Oregon is recognized.
Thank you, Mr. Chair. Strike the last word as to the amendment.
Gentleman's recognized.
So I just want to say, resorting to the phrase word salad when one doesn't want to accept what we're trying to do here is unfortunate, but not unpredictable. I just would say that this committee is the Judiciary Committee, not the take it for granted committee or the, yeah, we'll accept whatever you say, Mr. Herr committee. We're engaged in an oversight exercise, and the best evidence is the transcript. And the only way we would know if the transcript, excuse me, I said transcript, I meant the recording. The only way we would know if the transcript is inappropriate is by comparing it to the recording. So to sit here and say we haven't called into question the transcript when we're asking for the recording is to ignore the obvious, which is we need the recording to see if the transcript is correct. We need to check on these kind of things because these are within our oversight capability and certainly duty. So to ignore all this and bring all the other peripheral stuff up that we've had to endure for the last couple of hours is interesting, a diversion, and a lot of fun conversation. But the truth of it is, if we're going to engage in our oversight function, we need the recording. And that was proven, by the way, when the gentleman from Georgia showed an audio of former President Trump. Why didn't he just rely upon his words that were written in his amendment? No, he wanted us to see the exact words, hear them, and compare them then to that which was written down. Of course, we need to compare the audio to the written. That's why we have the best evidence rule. The best evidence is the audio. That's why we're asking for it. That's when we don't get it, we move to contempt to try to do so. I yield back.
Move to strike the last word.
Gentlelady is recognized.
So I'm a little confused because we keep hearing, of course, we need to match the audio with the transcript. And my understanding, based on the testimony we heard during the Herr hearing, was that it's a certified transcript. It's a certified transcript. So this is a red herring talking about needing to match the audio with what is written. It has been established that that is what has happened. So when we talk about wasting time, this whole conversation in which you bring up over and over and over again that we need to match these two things, it has been certified. We know what's in it. I yield back.
Gentleman from Wisconsin is recognized.
Well, yeah, this came up earlier. I mean, it's right here. The absence of a legitimate need for the audio recordings lays bare your likely goal to chop them up, distort them, and use them for partisan political purposes. So if they're identical and should be perceived as identical, then why is that actually in the White House's correspondence? I mean, they blew it. They blew it. They put the wrong line in here. Some attorney late yesterday was composing this and basically showed their hand, which is they believe it's going to be used for political purposes. Well, if the transcript and the recordings are exactly the same, why couldn't you just do that with the recordings anyways? I mean, it doesn't make any sense at this point. They need to turn it over. They need to turn it over at some point. I yield back.
Anybody else seek recognition? Gentlelady from Wyoming.
What I can't understand is why anyone would claim executive privilege when they've already waived it. The medium at issue isn't the deciding factor. By giving us the transcript, they've already waived any claim of executive privilege. So there is no legitimate reason to withhold the transcript, or to withhold the recordings. We're entitled to them. As has already been repeatedly stated, it's the best evidence rule. As the Oversight Committee, we're entitled to hear exactly what Mr. Herr heard. With that, I yield.
Gentlelady yield?
Yes.
Adding to that point, thank the gentlelady. I just note that I was kind of digging through my friend, Mr. Ivey from Maryland, was trying to filter through the letters and find what had been said about waiver. And the only thing I see is at the top of page 7, there's an argument that I note that the department's disclosure of the transcripts of the interviews does not constitute a waiver. You go on and read that paragraph, find a citation in that paragraph that says that once certain testimony has been released in written form, that there's some basis that you could possibly contend that another version of the testimony, in this case in the form of an audio recording, is protected from waiver. There's just not, you would think if they want to say there's an argument that there's no waiver, they could cite some authority from some court at some point in history that came close to addressing that issue and making that ruling. But there is no such authority, and it is absurd on its face. I yield back to the gentlelady.
Mr. Chairman.
Gentleman from California is recognized.
I find it particularly interesting that in this conversation about will the White House release the audio recording when we already have the transcript, we already had your guy come and testify and said that the president did nothing. But did you know that you all are sitting on 115 transcripts, videotapes, audio recordings for your Hunter Biden investigation that you will not release to the public? Do you want to release that right now? Are you willing to release that to the public and show us what you have? Because again, this all just seems really interesting that you get subpoenaed, you don't respond, but you are upset that the president and his team won't respond to that subpoena. You have a guy on your side who was investigated for sexual trafficking, and you're not interested at all in subpoenaing or getting any notes of that investigation, but you want every part of this investigation. And then with Hunter Biden, you've done a year plus of investigating him. You've found nothing. Your best witnesses are now locked up for lying to the FBI, but you won't give the public any audio recordings or video recordings. And I keep hearing this phrase by some drive-by lawyers over there of best evidence. Okay, well, isn't that the best evidence? So why don't you show us what you have? And if you're not going to show us what you have, tell us why you won't show the public what you have. Yield back.
Gentleman from California is recognized.
You know, my good friend from California makes a point, and I always take his point seriously. I'd like to make a point. The point is, this committee, back when Chairman Conyers was the chairman, asserted that when we're doing an investigation, whether it's an impeachment or an inquiry of more general case, and in the case of Chairman Conyers, whose picture is practically right behind the ranking member, Chairman Conyers said, we have to be the committee that oversees the president. We have to be. We were under Richard Milhouse Nixon. We have to be under George W. Bush. To give that up, simply because now the shoe is on the other foot, is to give up the authority of this committee and the importance of what we do. I agree with the gentleman from California that this should not be used for partisan purposes. I think Mr. Fitzgerald said very well that the accusation is probably false on its face. But if the other side were saying, well, let's make sure that the audio isn't released to the public, at least until there's a full committee vote, until we have had an opportunity to hear it in its entirety and see whether it gleans additional information, we probably would have a bipartisan moment. But we're not doing that. We're really debating the question of the authority of this committee. And just as Chairman Conyers grew the real respect for this committee in the Bates decision, which was taken not just through his time, but was continued, and today is what we rely on for whether or not someone is to appear before this committee from the White House, we have to do the same thing here. The committees of Congress may be political bodies, but so is the White House. And in fact, the other side of the aisle is constantly telling us so is the Supreme Court. If we are political bodies, that does not change our constitutional responsibility. So I, for one, will be voting to hold in contempt if we do not get that which we have asked for under some reasonable terms, which we have not even begun to discuss. That is what we're discussing here today. I hope that the gentleman from California will think again about where this body will be in 4, 6, 8, or 10 years, just as Chairman Conyers, Chairman Hyde, and other chairmen before them have asserted that Congress has a right, and consistently the court at all levels, under all types of courts, have held those rights to be reasonable if they are in fact pursuant to our obligation. And our obligation clearly is to oversee the Department of Justice. And I thank the gentleman and yield back.
Anybody else seek recognition? Gentleman from New Jersey.
Thank you, Chairman. Just quickly, just a few points to be made here. I mean, if we get down to the real issue, they're afraid to reveal the demeanor, which is the best evidence here, not just what you said, how you said it, did you ramble on, did you have cognitive thought here, were you just, not under any particular control of what you were saying or doing. And that's something the American people deserve to know. It's something we deserve to know. And that's point number one. Second thing is, there is an executive privilege here because it was given up when the transcripts were given to us. We know that. So again, what are we afraid of? Are we afraid to hear the audio? Why? Because I think there's concern that it's going to be very revealing as far as the cognitive state of this president. If there's no problem, if there's no issue, just send it over. We don't have to have this hearing. You know what? I think there's a good number of us wish we didn't need to have this hearing. It just would have been simpler to say yes, abide by the subpoena, give us the information, let us look at it. It would already be done. But it isn't, and we have a right to it, and there's no executive privilege, there's no protection. The information was already given in a transcript. Now the audio needs to be given too. I yield back.
Gentleman yields back. Gentleman from Georgia.
Thank you, Al. I have some short remarks. I find it ludicrous to think that my fellow members on the other side of the aisle believe that they have the ability to determine whether or not someone is mentally competent by listening to audio recording. I mean, that's all that you all want to have is just some audio so that you can probably splice and dice and then use it to mislead the public into buying your narrative. But the American people are not going for that. They see through the hollowness of this exercise that we're going through today. They know that the only thing you want to do is try to get something to embarrass the president with. And this is what you're reduced to after spending $20 million of taxpayer money, compiling a data bank of information which reveals no wrongdoing by the president. You were hoping to find some, but you didn't, and now you're reduced to trying to find evidence that he is somehow unfit mentally for office when people can see the man doing his job every day. They can see what he's doing, they can see what he's done, they can see him in action, listen to him. We don't need further waste of taxpayer money going down this rabbit hole any further. I ask my colleagues to get serious about it. We got stuff that we need to be doing on behalf of the American people as opposed to sitting up here for 4 hours now debating the hollowness of a resolution that you all are offering, trying to hold Merrick Garland to account for not turning over an audio file that really has no relevance to what the American people are going through today. Please stop this and let's get to work doing something that benefits the American people, and I'll yield to the gentleman from Tennessee.
Thank you, Mr. Johnson. I believe one of the members on the other side incorrectly said that there was something in her testimony that said the president was incompetent. He never said that. He never wrote that. No one has said or wrote that. He said he was a sympathetic character, elderly person who had a little problem with their memory. That's not saying you were incompetent. And nobody suggested that. The previous term we had, President Biden's first 2 years, has been compared to the 1964 Lyndon Johnson era as the most effective legislative actions, congressional actions in our country's history. The IRA, the quote-unquote bipartisan transportation bill, jobs and transportation bill, highways bill, the CHIPS Act, you name it. Biden got it done. He even got done finally after lollygagging monies for Israel and Ukraine. Far too late for Ukraine to resist the Russian expedited attacks, strengthened attacks while Ukraine was suffering without the equipment they should have had in the East. But they're still standing. We got them money finally, even if it was late, because Biden put it together. And we could have had and should have had a bill on immigration that the Senate was going to pass that would have dealt with immigration and not made it a political issue to dilly-dally up here for a year and let all these arguments that you make about these terrible people coming into our country continue to come into our country only if they advance the opportunity of having a terrible person become the President of the United States again. A person who has been said by more of his colleagues that he shouldn't get anywhere near the White House again. Almost all of his cabinet members. And the ones that haven't said that have gone to jail. Mr. Navarro, contempt. Mr. Bannon, going out of prison near you. Mr. Cohen went to jail for 2 years because he did what Mr. Trump asked him to do to work out the hush money payments to the porn star. He went to jail. You lay down with dogs, you get up with fleas. Be careful, my colleagues. I yield back the balance of my time.
The gentleman from Texas is recognized.
I thank the chairman. Wanted to try to recenter the conversation just for a moment and might engage with a colloquy with the chairman on a simple point. When the Democrats were in charge of the committee in 2019, as I believe the chairman has mentioned today, was it not true that they held the Attorney General of the United States, Attorney General Barr, in contempt for effectively redacting material from the Mueller report that he was legally obligated to redact?
Yes, it was grand jury transcripts.
And so that's the standard, just to be clear, set by our Democratic colleagues, was to hold somebody in contempt for doing what he was legally required to do under the law.
Yes.
And here we are having a conversation about an amendment, I believe, is what we're actually debating at the moment, an amendment to add language to clarify that we were in receipt of the assertion of executive privilege that we received a mere minutes before we began this markup here today, and that this amendment asserts privilege, it's asserting privilege after having, as the gentlelady from Wyoming was noted, effectively relinquished their claim to privilege, having provided the transcript, and that our position is that now have the transcript, that we want to be able to look at the actual audio or listen to the actual audio because of, to be very specific, the assertions by her throughout the entirety of her report that it was in fact the president's demeanor, the way the president was responding or his lack of response. And look, I'm trying to be careful, by the way. I mean, with all due respect to the assertion made about by the gentleman from Tennessee that, there were just some little problems with the memory. I mean, her report is littered and filled with concerns about the nature of the president's memory. I don't even want to go down that road. He's the president of the United States. I'm not looking to dive into that other than as it relates directly to this question about what we can take away from the actual testimony by the president to Mr. Hur. That's it. So back to recentering the question, all we're doing is debating this amendment that's talking about adding this language in about the assertion of executive privilege, which we are saying has already been essentially set aside by giving us the transcripts, and we believe that it is our oversight function to be able to simply listen to the audio file. The gentlemen agree with that, and I yield back to the chairman.
The only other part to that I would say is it was also leaked to the press. Like, it wasn't just given to the committee. And that's, will the gentleman yield? Or go, gentleman from New Jersey.
No, just real quickly, I mean, we were alluding to what was exactly said, and this is right from the report, because they didn't want to go forward with the case. And the reason they didn't is because Biden would be seen as a, quote, well-meaning elderly man with a poor memory. Not a little bit of a memory problem, not a little tiny issue, such a big problem that they felt that he was such a sympathetic case and it was so sad they wouldn't go forward with the case because the jury would feel bad for him because of his cognitive state. But those are an exact quote, what I just read. I yield back.
To Mr. Roy. Recognition. I'll recognize myself just for real quick. You know, we've heard a lot of different reasons about impugning what motivations are on this side of the aisle, but we've been here for 4 hours, and nobody's ever defended the DOJ's reason for not turning it over. And the reason for not turning it over is somehow it's going to have this huge chilling effect on all of these witnesses and the volunteering of cooperation with the DOJ if you somehow release an audio interview versus a transcribed interview. And I think that's a level of sophistication that quite frankly fails on its face in common sense. That is, I mean, the fun of it, we talk about waiving the privilege by giving the transcript, leaking it to the press, and all of those things, but that's the other part of this, which is just farcical on its face, is that somehow we are going to chill all of these DOJ investigations because of the medium in which we release something to Congress after we have already waived the privilege. And I think for all of the different things for 4 hours today, nobody's ever actually said, I can name 9 people who would have cooperated except you gave them a transcript instead of an audio recording. And because that doesn't exist, and it's an excuse, and it's an excuse that we got 1 minute before the hearing, which is why this amendment is important. And so with that, I yield back. The question will...
I'd just like to remind the committee that Donald Trump refused to be interviewed by the special counsel, and if he had been interviewed and it was tape recorded, and they could have used that, could have been used in his campaigns. And I think there's the idea that this could be used politically, while as far as the legal basis, all you need is the transcript. The audio is needed for politics, not for information based on what this committee's jurisdiction is.
Any question occurs on the amendment? All those in favor say aye. All those opposed say no. No. In the opinion of the chair, the noes have it. Oh. I'm sorry. In the opinion of the chair, the ayes have it. Roll call has been requested.
Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Issa? Yes. Mr. Issa votes yes. Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Aye. Mr. Roy votes aye. Mr. Bishop? Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes yes. Mr. Moran? Ms. Lee? Ms. Lee votes yes. Mr. Hunt? Mr. Fry? Mr. Fry votes yes. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Schiff votes no. Mr. Swallow? Mr. Swallow votes no. Mr. Liu? Mr. Liu votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Bush? Mr. Ivy? Ms. Ballant? Ms. Ballant votes no.
Clerk will report.
Mr. Chairman, there are 15 ayes and 11 noes.
The ayes have it, and the amendment is adopted. The question now is on adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the report. All those in favor say aye. Aye. Those opposed, no. And pin the chairs, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present. The question is on favorably reporting the report as amended.
Mr. Chairman, may I raise a point of order?
Sure.
And I won't insist on it. But ordinarily, the committee does not do markups when committees' bills are on the floor. The ranking member is on the floor managing those bills. He's not asking that the vote be delayed because of the time that's been put in. He would vote against it, and I just wanted to put on the record why it is rather unusual for us to be meeting, and I'm not even sure the rules permit it, but he would vote no, and that's why he is not here.
And I'm willing, and I think we communicated this to the minority staff. We're willing to wait for the chairman to come back for the final passage.
I think out of deference to the other committee members, he's not asking for that.
Okay. All those in reporting quorum being present, the question is on favor of reporting the report as amended. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it.
We have a roll call vote, Mr.
Sure.
Chair?
The roll call being requested, the clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Issa votes yes. Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Gooden? Mr. Gooden votes yes. Mr. Vandrew? Mr. Vandrew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes yes. Mr. Moran? Ms. Lee? Ms. Lee votes yes. Mr. Hunt? Mr. Fry? Mr. Fry votes yes. Mr. Nadler? Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Schiff votes no. Mr. Swallow? Mr. Swallow votes no. Mr. Liu? Mr. Liu votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Bush? Mr. Ivy? Ms. Ballant? Ms. Ballant votes no.
Have a chance to communicate with the ranking member and see what his wishes are for being recorded. And then we'll move into Mr. Ice's legislation once we get an answer from the ranking member. maybe just a few minutes. We're gonna let Mr. Nadler leave the floor and come here and vote on the report. So we'll have committee will just stand and committee will just take a break for a second. I've been corrected by the parliamentarian, and then we'll once Mr. Nadler gets here and votes, we will move to Mr. Ice's legislation. For Republican members, we have food back there if you haven't eaten. I don't know if we have enough for the Democrats. Yeah, there's probably some. There's probably some left.
Ms. Ross, you're not recorded. Ms. Ross votes no. Ms. Escobar votes no. Mr. Massey, you're not recorded. Mr. Massey votes yes.
Was the gentlelady recorded?
Ms. Bush, you're not recorded. Ms. Bush votes no. Mr. Bishop votes aye. Ms. Sparks votes yes.
The gentleman is not recorded.
Mr. Nadler votes no.
The clerk will report.
Mr. Chairman, there are 18 ayes and 15 noes.
The ayes have it. The ayes have it. The report is ordered to be reported to the House. House members will have 2 days to submit views. Without objection, the staff is authorized to make technical and conforming changes. We now call up. You want to take it?
Pursuant to notice, I call up H.R. 7803 to amend Title 35 United States Code to provide a good faith exception to the imposition of certain fines and for other purposes, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 780.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from California, Mr. Issa, for an opening statement.
Thank you, Mr. Chairman. In short, this bill is a win for small businesses and long overdue. Right now, small businesses may qualify for reduced application fees with the United States Patent and Trademark Office when filing for patents or trademarks. Under 35 U.S.C. Section 41 and 123, a small business may claim small entity or micro-entity status. For example, the cost of filing a utility patent is $320. A small entity, however, is charged only $128, and a micro-entity is charged only $64. I might note that those are set by the PTO, and under this bill, we will continue to have the Patent and Trademark Office set them. However, when Congress passed the Unleash American Innovation Act in 2023, a law required the USPTO director to impose punitive fines on entities falsely asserting or certifying their entitlement to these reduced fees. We did that with good intent. However, the fine is in the amount not less than three times the reduction of fees. Right now, there is no exception provided by law for an entity that made an error in their filing in good faith. An example of good faith error is if an employee is mistakenly categorized as a contractor. Another example is if a good faith mistake is made regarding the belief as to the number of employees qualifying under the entity. The impact of these punitive fines can be harmful to small businesses, and if they had no intent, we do not want them fined, we want them corrected. The harsh fines may deter them from seeking benefits of small or micro entities, since their status of savings is far less than the possibility of a treble fine. To ensure small businesses take advantage of reduced fees, this bill gives the director authority to waive such penalties if an entity demonstrates they had a good faith belief. I am pleased to introduce this bill with my ranking member, Mr. Johnson, and I hope we will all support it. We believe it's a technical and correcting one by giving the authority to the PTO to waive the fees in a good faith mistake. And with that, I yield back.
The gentleman yields back. The chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. H.R. 7803 makes a minor technical change to give the Patent and Trademark Office the flexibility to decide when to penalize patent applicants for false certifications of eligibility for fee reductions. When Congress passed the Unleashing American Innovators Act as part of the government funding package for fiscal year 2023, we did so with the intention of making patents no longer the sport of kings, but an opportunity for inventors to make a decent living. Innovators should not have to work for a big tech company, major manufacturer, or any other powerhouse of industry to be able to file for a patent. But that is exactly what often happens. Financial hurdles associated with obtaining and owning a patent, from hiring a lawyer to search for prior art to paying standard application fees, prevent individuals from seeking patents for their inventions. Barriers to entry like these hurt everyone, but above all, they hurt women, veterans, and minorities who often do not have the resources to go it alone. The result is that fewer ideas make it out there into the American innovation space. All of our talent becomes siloed in just a few companies in just a few industries, and prospective creators shelve their ideas for another day. The Unleashing American Innovators Act sought to disrupt the current state of play by making a series of good government changes to the way the PTO works, including by increasing the discount on fees for small and micro entities, while also imposing penalties for making a fraudulent certification to obtain that discount. But I'm sure many here will be shocked to learn Congress sometimes makes mistakes. And in creating these new fee waivers and associated penalties for trying to abuse said waivers, we neglected to consider that applicants, too, can make honest mistakes in their applications. If innovators are too afraid to apply for financial exemptions because penalties for honest mistakes can lose them a chance at a patent, then all our improvements may as well simply not exist. Failing to account for good faith mistakes harms the exact same people that the Unleashing American Innovators Act sought to help. Individuals and entities that can barely afford filing fees certainly do not have the financial resources to weather a hefty fine. Moreover, unlike large entities, for these filers, the prospect of losing the patent associated with an erroneous application could very well mean losing everything. Smaller entities, therefore, are the most likely to avoid the risk of applying for the very programs that exist to help them. H.R. 7803 would correct this minor error. Under this legislation, a U.S. PTO director would no longer be forced to fine a good faith actor that erroneously asserts that they are entitled to a fee reduction for small or micro entity status. By allowing for honest mistakes in the application process, this technical fix will ensure that everyone has a seat at the table. I thank Congressman Issa and Congressman Johnson for their leadership on this legislation, along with Congresswoman Ross, the original sponsor of the Unleashing American Innovators Act. I urge all members to support the bill, and I yield back the balance of my time.
Gentleman yields back without objection. All other opening statements will be included in the record. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I'm a proud co-lead on this bill with Chairman Issa. This bill is a technical fix that would allow the Unleashing American Inventors Act to work as intended, thereby, as the title says, unleashing the power of America's smaller and medium-sized inventors. The American Innovators Act lowered the barriers to entry for individual and small inventors by, among other things, creating a reduction for the application fees for small and micro entities. To protect against abuse, the legislation imposed fines on companies that applied to these programs fraudulently. But because it failed to give the USPTO director the ability to waive the fines in case of a good faith mistake, the legislation inadvertently disincentivized the use of the fee reduction programs for small and medium-sized entities that were not sure if they qualified. As members of Congress, it was never our intention to penalize these small and medium-sized inventors who are vital to our economy and to our innovation landscape, but who lack the resources of the mega corporations. This bill would fix the law to allow them to apply for reduced patent application fees if they think they might qualify without fear that they will face a crippling fine. The fix will allow innovation to flourish for inventors in my hometown of Atlanta and all over the country, and I urge my colleagues to support it, and with that, I yield back.
Gentleman yields back. He seeks recognition. Reporting quorum being present, the question is on favorably reporting the bill. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and the staff is authorized to make technical and conforming changes. We'll come back next Wednesday at 2 for those last 3 bills. Because they took away Friday, or we'll have to do it Wednesday. That concludes the committee's business for today. The committee is adjourned.